matter between the party,
Hmm.
dispute regarding matrimonial dispute, my lord.
Hmm.
Then, my lord, annexure 2, my lord, page 11,
Yes.
both party going to already settle the matter.
My lord, my lord, in this case, my lord, file with my friend Maharaj. He has not come, my lord, since item 48 is with his
No,
file.
this is the matrimonial dispute.
My lord.
It appears they have settled.
Hmm.
And they are staying together now.
Must change together.
So then state doesn't have much role to play. Let them. What are 498?
My lord.
This is the affidavit. Vishnu Priya. Who is Vishnu Priya? Vishnu Priya. And the Vishnu Priya affidavit is there. Where is the other? Where is the other affidavit of the?
Only the, my lord, the affidavit of the parties, Vishnu Priya affidavit is there, my lord. Before the oath commission. My lord.
What is the terms of compromise?
My lord,
What is the terms of the compromise? They have started staying together.
staying together.
Living peacefully. with my
Living
husband.
peacefully.
Okay. आपको किसी problem नहीं? Who you are appearing for Vishnu Priya?
Yes.
You identify? Yes. The present petition is filed for under section 4 into PRPC seeking passing of FIR number 170, FIR PS case number 170 of 2023 in PS Mangalabag, corresponding to GR case number 483 of 2023, pending in the court of JMFC, City Court, District Cuttack. Under section also 498. Okay. The informant in this case has been impleaded as opposite party number 2. So the informant is the wife of informant opposite party number 2 is the wife of the petitioner. The informant has filed an affidavit dated 5/10/2023 inter alia stating that he has entered into settlement with the petitioner, and now they are staying peacefully as husband and wife, and there is no dispute subsists between them. So therefore, she doesn't want to proceed with the matter, and accordingly, prayer for passment of the FIR mentioned above. And so-and-so appears for the opposite party number 2, petitioner, and so-and-so appears for opposite party number 2. They identify their clients. Those are clients who are present in the court today. Next one. In view of the fact that the parties have settled their dispute and started residing peacefully, and the opposite party number 2 being the informant doesn't want to proceed with the case. It is a fit case for passment of the FIR. Accordingly, the petition is allowed, and FIR number so stands quashed.
Oblige, my lord. Grateful.
Yes. Item 55. 55 be same. Will be taken as first, right? Okay, 55.
Friday, this matter was there. Your Lordship almost dictated the order, and Your Lordship wanted me to make a statement whether 82-83 process has been initiated or not.
Yes.
This is Belgium matter.
Yes.
And my instruction is 82-83 process has not yet been instituted. I have got written instruction from the.
I have already dictated the order. Is it? Is there? Show me.
No.
But this is the case where the
NBW was issued in
2015.
2015. And while dictating the order, your lordship entertained it out whether 82, 83 process has
No
been
82.
It is not there. I have got
The Land Council for the petitioner submits that despite the fact that in the year 2015, that is on 5/6/2015, NBW against his client was issued, but the trial court has not proceeded against him to declare him as a proclaimed offender. बाकी सब order would have same रहो and
obliged.
you will have to appear and take bail and all. Huh? That part I might have given the statement. That you check it up. You'll appear and take. Okay. Please put. Yes.
Item 1, may please your lordship. The petitioner challenging the order dated 26/12/2022, Annexure 3, your lordship.
Answer
In this
3.
case, your lordship, cognizance has been taken against the petitioner under section 20B2C and 29 of the NDPS Act. The fact of the case is that your lordship, the petitioner is the owner of the vehicle. The vehicle has been taken by some persons for transportation, your lordship. On the eventful day, the vehicle has been caught hold by the police officials, and 3 persons have been arrested on the spot. 1 person arrested on the spot, and 3 others have been arrested.
Your vehicle was stolen?
No, not stolen, your lordship. It has been taken as the hire purchase, under hire, your
All
lordship.
that those are material.
Yes,
right?
yes, your lordship. And furthermore, lordship, the accused persons on whose possession the contraband has been recovered, they have acquitted by the learned trial court, your lordship. And the judgment has been passed during pendency of this case. The judgment has been passed acquitting those persons.
Executing who?
Your lordship,
Who all are acquitted?
3 persons have been acquitted, your lordship. That is,
All the three, those who have been apprehended from the spot.
apprehended, your lords. They have acquitted by the learned trial court. Kindly have a glance at the judgment of the learned court.
Have you filed this document?
No, I didn't have. it
You
is-
filed this document?
Yes, I will file this.
File the document. On merit, they have been,
Yes, your lordship.
it was, what is the finding?
Finding that your lordship may place the
You
finding.
just tell me the finding.
Finding is that the 41, 42, the provisions of 42
Was not followed.
not followed. Section 50 is not also followed.
Right.
For that reason, there is the burden of proof lies on the prosecution to prove his case. The prosecution fails to prove this.
We just
and
check it up.
acquit.
If the main accused are acquitted
Malad.
and he was only, he is the owner of the
Owner
vehicle.
of the
Malad.
vehicle.
He was not arrested during course of trial for that.
So why unnecessary putting him to trial?
Malad, check
You
up.
know that he will be acquitted.
Malad.
That is one of the tests.
Malad.
Another-
One of the tests, if you know that the trial will be a futile exercise, then 482 can be exercised.
Right.
Just check it up and tell me.
And the judgment of this honorable court.
Monday.
Yes, sir.
Monday.
And the judgment of this honorable court also I am handing over to my.
Monday, not Monday, that is on Tuesday.
Tuesday.
Place it on record with an affidavit.
Item 2.
Yes.
I have filed this application for
Call him. Learned counsel, let's go.
Monday.
Excellent. Record my number. Learned counsel for the petitioner submits that, how many accused were there
Your lordship, all
total? Give me that
judgment, your lordship.
acquittal judgment. Judgment by which the other people were accused.
Yes.
Just now you have told me.
Yes.
I'll just note it down so that it will be. How many accused? 3.
3 accused, your lordship.
You are the 4th one.
I am the 5th one. Another one is absconded. He has not.
Who is he? What is his role?
He is not also. He is traveling on the vehicle. That is the allegation in the charge sheet. There is nothing, your lordship. My case is that my vehicle is.
How many kgs?
129 kilos.
The learned counsel for the petitioner submits that 3 accused persons, namely 4 accused persons, namely Rajesh Chandra Sahu, Arjun Behra, Devraj Pradhan, and who is the absconding?
And Garner Rakesh Chandra Sahu is the present petitioner, your lordship. And then there is Arjun Behra.
Arjun Behra is there already acquitted. Who is the guy who is you should be ready with the names and all.
I am giving the name, your lordship. That's okay. Named in the FIR, your lordship.
Charge sheet against 3, my lord. Charge sheet against 3.
Four is
Okay.
Four accused persons were apprehended from the spot. How many kilos you said?
129 kilos. Your lordship.
And 129 kilos of ganja was seized from there. Urissa. 3 accused out of them, namely Rajiv Chandra, Arjun Behra, and Devraj Pradhan, were put to trial for the alleged offence under section 20B. You take it, huh? 20B and 29 so and so. I had order dated 14/8/2023. The learned special court, Pulwani, Gandamal, acquitted all the 3 accused persons. Also, petitioner, as per the prosecution story, petitioner is the owner of the vehicle, owner of the offending vehicle, from a vehicle from which the contraband was seized. Except the said allegation, there is nothing on record against the petitioner. So he submits that after having after the main accused persons having acquitted, the trial sought to be initiated against the petitioner would be a futile exercise. Therefore, he seeks indulgence of this cause. Next, the petitioner is directed to place on record the order dated, judgment dated 14/8/2023, passed by the special court Pulwani with affidavit, and at the time of filing this petition, this acquittal order was there,
Not there.
and at the grounds insofar as the present petition.
One more judgment of this.
You rely on that day.
If you.
Yes.
Item 2.
16, huh? 16, yes, 2.
Item 2, pass over.
Pass over. Yes.
Item 3.
Yes.
Yes, thank you. In this case, the petitioner who is the object part number 2, the challenging the obvious order of passed by London JMSP1 Bhadrak on dated 28/2022, as well as the FIR dated 24/2022. All ground, but I am already facing a proceeding by the object part number 2 under the same offence 498A and allied offence under the annexure.
How can there be a 2 FIR for the same offence?
First of all, she filed a complaint case. I was facing trial in that matter. We don't kindly peruse the annexure number 3. Annexure number.
Yes, Annexure 3. This is Purana Bazaar FIR, Bhadrak.
In that case, Milord annexure, annexure 5. This is 1CC case where I am facing trial on the basis of the content of the petitioner, and the offence against me is 498A, 294, 323, 354, 506, 10 set of offence pertaining to the matrimonial offence. Now, Milord, the irony of this case is that after filing, taking all these grounds, Honorable Judge Family Court has directed the petitioner, opposite party number 2, to resume her conjugation with me. That order was passed by the Honorable Judge Family Court Bhadrak Milord under annexer 4 page number 63.
Hmm. Yes.
Milord kindly be pleased to peruse that the date of judgment is 4/11/2022.
Hmm.
After getting this judgment, being vindictive, which is already always with me and my family on
What is
24th.
this, what is this judgment?
Judgment is her claim is rejected and she was directed to resume a matrimonial life with me. Under section
This is
9 of,
section 9.
yes, Milord. Restitution of conjugal right.
Section 9 was moved by you.
Yes, Milord.
Yes.
से judgment मिलला 4 तारीखरे 24 तारीखरे मिलॉर्ड she filed FIR just to
But what happened to the earlier complaint
that,
case?
I am facing trial milord in that case.
Yes. Yes, Mr. Gada. How can there be two FIR?
My lord, that is true, my lord. But in fact, my lord, my lord and friend given the order that in one case, my lord, earlier case, my lord, since 28/11/22, it shows that, my lord, at page 90, in
Yes.
view of the direction of the CJM Bhadrak, by the order number 48, 28/11/22, the case record is withdrawn from the court and transferred to the court of
Milord, that is due to function of the new courts. That is from withdrawn from
No.
one court and transferred to another court.
the can't, my lord, first.
Okay.
New JMSC.
Issue notice to the opposite party number 2. Mr. Ragada waves notice on behalf of opposite party number 1 state. Status report in regard to the pendency of the case number 1CC case number.
One
This
is
is
case number milord
4184 up to
The other
17 be placed on record by next date of hearing. Okay, file repeated 70. Next date. First week. 5th, 6th, whatever. Next,
Item 4.
No, item 4 can be taken out 2 weeks after my lord. Today,
2 weeks. 2 weeks.
My lord, today I am appearing.
Yes, no problem. Yes. February, end February. You original market February.
Item 5.
Yes,
May 3 your lordship.
yes,
Lordship may kindly turn to page 30, last page.
30, okay.
Order taking convenience on the challenge.
Yes.
Page 30.
Geographical indication of goods, registration and protection is 19 from IO. If it is accused from there is the same form of check is made out against. What is this 39 geographical?
Sambalpuri Bandha Sari.
Huh?
The allegation is that they are duplicating Sambalpuri Bandha Sari.
Oh, that those kind of projection, like 63, 63, 64 of copyright act,
Man,
like that. Okay. Okay.
my submission is that it has not been, investigation has not been done in the manner required. Lordship may kindly turn to
Come to page 14. What is this FIR? Where is the charge sheet is filed?
charge sheet submitted.
Where is the
That
charge?
my provision.
You have not filed the charge sheet copy.
Charge sheet I have submitted.
Where is that?
Annexure 1 series.
Series, okay.
Fine.
Okay.
Annexure 2 is the order taking cognizance.
Okay, okay. So that is
After
series.
charge sheet was submitted, cognizance has been taken.
Okay. FIR and charge sheet. Okay.
Man,
What is the charge sheet? Let us see. What is the allegation?
yes, sir.
Jagdish Chandra Neemchan. Allegation in the charge sheet, let us see.
Man,
Page 14.
page 28.
38, huh?
Shall I place it? Shall I place it?
Yes, yes.
On 21/4/17 at 1:30 PM, complainant Upendra Kumar Detta, son of so-and-so, Assistant Director, Textiles, Bargarh, along with Ramchandra Ghosh, Secretary, Sambalpuri Vastralaya, so-and-so, and Vasanta Kumar Mehe, presented a written report to the effect that they, along with 28 others, are authorized users of registered and certified geographical indication in respect of Sambalpuri Bandha Sari and fabrics under the geographical indication of Goods Registration and Protection Act 1999. One MS Bharat, Mohan Industries, so-and-so, are using their GI registered name Sambalpuri Bandha Sari and fabrics illegally and selling them in the market in violation of the provisions of the GI Act. This company has displayed duplicate Sambalpuri Bandha Sari and fabric by using the name of Sambalpuri Bandha Sari and fabric by the unauthorized user company. The goodwill of GI item is affected and tarnished. The consumers are likely to be misled, induced, and
Next paragraph. During the investigation, the complainant and other witnesses have
other witnesses
examined
examined
spot
spot has been
visited.
visited, see the alleged sari along with original Sambalpuri sari and the exhibit was sent to Director Textile and Handloom, Government of Orissa, Satyanagar, Bhubaneswar for examination and opinion by letter number 72. Subsequently, 2 reminders of have been sent and received the opinion on the violation of GI from the Director of Textile and Handloom, Government of Orissa. The reply to the query is there is GI registration in the name of Sambalpuri Bandha Sari fabrics against the sari mark.
Who you are the director of Bharat
No,
Mohan Industries.
I am the director of the company which is alleged to have been committed this.
That is Bharat Mohan Industries,
yes,
Pali,
Yes,
Mewar, Rajasthan.
yes, madam.
You don't have a registration certificate.
No, that is the allegation. My submission.
That has to be tested in the trial.
Madam,
That
No.
has to be tested in the trial.
no, that has to be tested.
LS sari produced by Bharat Mohan Industries
submission
Mark
is-
B violates the GI registration of
Right,
under
right,
section
right.
38, 39
Madam,
and 40 of the
Your
Act.
Lordship, kindly see. My allegation is, Your Lordship, may kindly see page 6, IV, ground IV.
Yes.
For that, the law as per subsection 4 of section 50 is very clear that before making any search and seizure.
IB, huh?
Madam.
Yes. For the law is
For the law as per subsection 4 of section 50 is very clear that before making any search and seizure, if the IO is satisfied that offence referred to in subsection 3 of section 50 is committed, he shall obtain the opinion of the Register of Geographical Indication on the facts involved by the opinion so obtained. Since the statutory provision of law provided under subsection 4 of section 50 GI Act has been violated and not followed by the IO while making seizure on 21/4/17.
you are questioning the seizure,
My lord.
the procedure followed in the seizure.
Madam.
That can be also a defense. And what I'll do is at this stage, I'll not cause, but I'll keep everything open for the purpose of arguing at the
If
stage of
my
framing of
lord,
charge.
if once that is to be held not to be violating that provision, then entire prosecution
At
will
the
go.
cognizant stage, I can't go into all this.
They
It
have to-
needs an extensive hearing, and
No,
I
no,
will keep
they-
it open.
In the charge sheet, they have to say so, because this is the prescribed law. They have to say that the investigator, a mistake therein may be taken into consideration at the stage of trial. But-
Procedural mistake.
No, any mistake, if at all there is that can be taken into consideration at the time of trial. But why should I face trial when on the face of it,
You are on bail.
well, yes,
I'll keep it open for the purpose of arguing it in extenso
at the.
at the stage of
only
framing of charge.
Only this is to let them satisfy that it is not to be taken into consideration at the.
Maybe you are correct, but this needs a extensive hearing at the court at first instance.
Well, that will be considered on the basis of evidence led.
I'll-
But on the face of it, my submission is that the IO has
Right.
not said that they have taken that into consideration.
You are absolutely right. I'm keeping it open and giving a direction to the trial court to consider this.
Well, I will have to face time.
No charge if you can be discharged. also.
Let them take instruction on this alone.
It's better that instead of wasting, you can argue that you can get in discharge. Unnecessary, it will be prolonged. So I will give you an observation, so it will help you.
At the time of trial.
Yes,
At the
yes.
time of
Charge.
charge.
Charge frame. You argue this point. This is a very vital
My-
point,
my-
you know. If the procedure is not followed, everything
my-
collapse.
Yes.
He may be discharged from
But
the.
in 482 stage, in the
Okay,
cognizant
okay.
stage, it's not fair.
Now,
for me.
now I agree to whatever your doctor is saying.
Okay, right. on.
Jodio, even if it would have served me better, but you not simply saying let it be so.
No, it is the court of first instance, you get the opportunity of
Well-
better hearing.
Well,
Right. on. The by way of this petition, petitioner is seeking enforcement of the impugn order dated 19/3/2020, whereby cognizance of offense under section 39. Under section 39 of Geographical Indication of Goods bracket Registration and Protection Act 1999 is taken against the petitioner. Full stop. The allegation against the petitioner is found from the charge sheet is that without having he is the director of it's a company.
Farm.
Director or what? What are you? Huh?
Page para 1 may kindly see.
He is running a industry in the name of Bharat Mohan Industry at Pali, Marwar, Rajasthan. Rajasthan. Without having GI registration under section 38, 39 and 40 of the Act 1999, earlier Act, referred to Act 99. He has been the company he has been producing Sambalpuri.
It is only for section 39.
Yes, Sambalpuri sarees and marketing the same. Therefore, apparently he has violated the provision under committed the allegedly committed the offence under section 39 of the Act. Full stop. The counsel for the petitioner pointed out that the seizure, the procedure established under law for the purpose of seizure under this Act has been blatantly violated, and he emphasized the specific ground he has taken in the petition in ground number 4. Ground number 4, Uttarakhand. Ground number 4. Full stop. Next, having heard the parties at length, I am of the considered view that the petitioner should ventilate his grievances at the stage of framing of charges. Instead of pressing the present petition, where the cognizance order dated, the order by which the land trial court has only taken cognizance with the liberty to raise all the contentions open to him at the stage of trial. The present petition is disposed.
At the time of framing of charge.
Framing up.
You are sitting at trial.
No, framing up charge. At the stage of framing up. Yes.
Item 6.
6. Yes. Withdraw. Memo withdraw. 6.
Item 7.
Take the memo and
May I please, Your Lordship?
Hmm.
For the petitioner, before your lordships,
yes.
challenging the order dated 17/4/2023 for rejecting the petition under section 227 of the CRPC. The discharge petition has been rejected by the court below.
Okay.
And I have the petition has a challenge on the ground that in the absence of a single
Kolahandi. Yeah, what is this?
Kolakhandi, alias MD Sakhavat.
You are one of the accused.
My lord.
Okay.
Except the confessional statement of the co-accused.
You are accused number 4.
Well, in
Yes.
charge. Except the confessional statement of the co-accused, not a single piece of evidence is available against the present petitioner. Neither he was present at the spot, nor anything has seized from his possession. Nothing, well.
29 NDPS.
Well,
What is the seized amount?
seized amount, my lord, 1,047. My lord. 1 kg 25 grams. from the possession of the three accused persons. Getting a reliable sources, the IO proceeded to the spot and found the three accused persons and seized the brown sugar from those three persons, and they have stated that they have procured the said brown sugar from the present petitioner.
Last paragraph of the impugned order, my lord, relevant, my lord, as
We
it
have
was
relied upon Tufan Singh and Sanjeev Chandra Agrawal.
My lord,
Sir,
even though
last paragraph, not only confession statement, but also two of the independent witnesses, my lord.
My lord,
Written in the last paragraph.
I'll place
from
my
the
lord.
material, read it, 19, page 19. From the material in this case, in
Lord.
the case on record, it reveals that above named accused
The
is a
independent-
drug peddler and carrying on illegal business through the accused persons, namely Ranjan Patsani, so and so, Mahapatra, and that on such as the STF seized 1 kg 25 gram of brown sugar. It is not even ganja, brown sugar. Further, the above, the named accused is not only entangled in the case, you are the peddler, you know, you
My
are
lord,
engaged
the
people.
independent witnesses have stated that ବୋଧେ ସେମାନେ brown sugar ଆଣିବାକୁ
ତାପରେ ଲେଖା ହେଇଛି, ତାପରେ independent
I am
witnesses
placing the
who are
statement of
also
the
co-villager
independent
of
witnesses.
the accused.
Omni also.
I will not pass.
My lord, has there any?
You can argue as much as you like.
My lord,
Because see, in the Orissa, this has to be brown sugar
କିଛି
business.
ତ materials
Still, brown sugar in Orissa also in the villages.
In your-
they started.
in
It's a
her-
manage, I tell you.
in his confessional statement,
Maybe.
he has stated that ସେ ଯେହେତୁ inform କରିଦଉଥିଲା police କି
The very fact that you are a peddler, I will
No.
not pass.
କିଛି not a single
Maybe you
matter.
face the trial.
My lord, I'll
You are on bail.
bail, my lord.
You are on bail.
My
No?
lord, my lord,
Happily face the trial.
one thing, my lord, rejection impugned order that simply London court will has observed that he is a peddler. My lord, the statement of the independent witness, can I place my lord? ସମସ୍ତଙ୍କର ଗୋଟିଏ ବର୍ଷ ବୋଧେ ତା ଘରକୁ ଯିଏ ଯାଉଥିଲେ ସେମାନେ ବେପାରୀ ହେଇଥିବେ।
Maybe. See, the investigation is always a faulty investigation here.
ଖାଲି copy
And it
paste.
is, the investigation is motivated by many reasons. But the fact remains that you are a peddler, cannot be ruled out because this is a menace in Orissa now. Slowly it is increasing in Orissa. This has to be, discouraged.
And even though the
So if the 482 at this stage, if the court will start interfering, then there is no end to it.
ଚାର୍ଜ ବେଳେ ଆସିଛି discharge ବେଳେ ଆସିଛି ମୁଁ cognizance ରେ ଆସିନି ମାନେ
ଆପଣ କଗ୍ନିଜେସନ ଆସିନାହାନ୍ତି, discharge ରେ ବି try କଲେ ହେଲାନି, ସରିଲା।
Discharge ବି ସେ revision କରିବା କଥା actually.
ମୁଁ
Revision କରିବା କଥା।
କିଛି ବି materials
You have a right to ask for discharge. The court has applied bind and court has given in the page 19, just see.
my lord ନାଇଁ
At
7
the
to 8
base of it, how can the High Court will end?
even though Tofan Singh
Something will not help you. Vikitrananda Mudali will not help you. Tufan Singh will not help you. Nothing will help you.
Independent witnesses here, my lord.
ଗୋଟେ ବି ସବୁ 7-8 ଜଣଙ୍କର କପି ପେଷ୍ଟ ଯାହା ହେଇଛି 8 ଜଣ
ସେମିତି ହୁଏ ଆଉ କଣ କରିବେ ଆପଣ?
ମୁଁ ଟିକେ
ଆପଣ ଚାର୍ଜ ସିଟ୍ ଗୁଡା କପି ପେଷ୍ଟ ହେଲା ବେଳକୁ ଆପଣ 161 ଷ୍ଟେଟମେଣ୍ଟ କଥା କହୁଛନ୍ତି।
ସେମାନେ କହୁଛନ୍ତି
ଆପଣ ଗଞ୍ଜା କେସ୍ ରେ ଆପଣ ଦେଖିବେ 4ଟା ଚାର୍ଜ ସିଟ୍ ରଖିଦେଲେ ସବୁ କପି ପେଷ୍ଟ ଥିବ, ନା ଗୁଡା ଚେଞ୍ଜ ହେଇଥିବ, କଣ କରିବେ? This is the level of investigation.
ସେଇ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ କହୁଛନ୍ତି ସେ 3 ଜଣଙ୍କୁ ଆମେ ଚିହ୍ନିନୁ, ଇଏ ପିଟିସନର ଘରକୁ ଯିଏ ଆସନ୍ତି ବୋଧେ ବ୍ରାଉନ ସୁଗାର ହେଇଥିବ।
The veracity of
ଆମେ-
161 statement cannot be tested in a 482 petition.
No,
You have to face the trial. Maybe right, maybe wrong.
ନା ସେଇଟା କୋଏକ୍ସିଷ୍ଟ
Maybe right, maybe wrong. But in
But the
482,
statement-
can I go into 161 and try to find out the
the
veracity?
London court below has observed that the independent witness have whispered the name of the present petitioner. ସେମିତି କିଛି ଥିବା ଦରକାର ଯେ
The investigation
Prima facie-
officer has right to use the technology.
prima
Right to use
facie-
the technology
my
of
senior
copy
is
paste.
stating that prima facie matter.
Basically-
Single
Anyway, will you withdraw or you want unnecessary? Don't invite. Better withdraw. Better withdraw.
ମୁଁ ଏଇ ଜିନିଷ ଗୁଡାକ ଅବଜର୍ଭ କରିବି ଟ୍ରାଏଲ ବେଳେ
Obviously, it is open.
ଟିକେ observe
Shall I observe it? The petitioner has essayed the order dated 17/4/2023, by which the learned, which court is this? Learned Let special judge NDPS Act Khurda has turned down his application seeking discharge. Full stop. This court is not inclined to interfere in the matter at this stage. Let counsel for the petitioner submits that he may be permitted to withdraw the present petition, reserving his right to hesitate all the available points at the stage of trial. Full stop. In any case, the right to hesitate, right to hesitate all the points available to an accused
In case,
is available at the trial stage. Hence, the liberty is granted to the petitioner to raise the issues available to him during the trial. Accordingly, the petition is dismissed.
my lord.
Next,
Any,
liberty is granted. All the rights are there.
oh, withdraw.
What that will not prejudice you, even if it is just not.
Simply use.
Why it will not prejudice you? In any case, you have the right to raise all the issues. That's what I say. Who stops you? You can do it. It will not prejudice you. Anyway, let it be like. Okay.
Item 8.
Yes. Yes, pass over. Next.
Item 9.
Yes. Yes.
Petitioner's vehicle was seized under the NDPS Act, ma'am. And it was released by the court below. And put a condition that I will punish the cash security of rupees 50,000
Vehicle.
vehicle.
What is this OD5E?
Bolero vehicle.
98. It's a car.
Bolero vehicle, my lord, that,
Bolero.
that is imbue, multi-utility vehicle, my lord.
You are the owner.
Yes,
You are also an accused.
no,
You are employing this vehicle only for this purpose or something else also?
no. Ma'am. Yes, the law and court below release the petition.
Yes. Mr. Ragada.
My lord. Lordship. The lordship may
Indemnity bond.
Independent.
property,
Property security.
renewed the property security instead of cash.
He is not accused.
Property,
who was
property
paying
ଦେଇପାରିବ.
Other 3% who are
How it has gone to them?
driver taken the vehicle and used it in the side business.
You are saying where and where the vehicle was
Vehicle was,
apprehended?
my lord, vehicle was seized at Noagarh, ma'am.
And you are saying it?
I am Bhubaneswar.
ନୟାଗଡ଼ ପଳେଇଲା ଆପଣ ଜାଣିନାହାନ୍ତି ଆପଣ ଗାଡି
Everything known to him. But in fact, my lord, instead of 50,000 cash security, it may be stated as property security. Property, ଜମି ଥିବ ସେଥିରେ ଦେଇଦେବା ହେଇପାରିବ.
Where is the order?
My lord, page 10, ma'am.
Page 10, na? The petitioner being the owner of the vehicle, owner of the offending vehicle, owner of the vehicle, the vehicle number so and so, the vehicle number OD 05E9298, 98 so and so, was was driven by the accused in the NDPS case, was apprehended near Nimapadana. Where is that?
Noagarh.
Nayagada. Full stop. The petitioner is the owner of the vehicle. Full stop. He is not an accused in the offense under NDPS Act. Full stop. He moved an application. He has moved an application under section 457 CRPC seeking a release of his vehicle on Superdari, in inverted comma Superdari. Superdari. What is Superdari? Superdari. Okay. Superdari. The court, while releasing the the court, while directing to release the vehicle on Jimanama, asked the petitioner to furnish cash security of 50,000. only along with the property surety and the indemnity bond. 1 lakh property surety to achi.
ଅଛି
1 lakh property surety achi, indemnity bond achi.
ଥାଉ ଏଇଟା
তো এটা থাও সেটা ঠিক আছে asked the furnish cash security of 50,000 and along with the property surety oblique indemnity bond of rupees 1 lakh. Full stop. The petitioner is aggrieved by the said order to the extent that he is not in a position to furnish this cash security of 50,000 rupees. Full stop. Heard the written counsel for the petitioner and the written counsel for the state. Having considered the facts of the facts and circumstances of the present case, the order dated so and so, order dated, impugn order dated so and so, on order ek bar requisition stands modified to the extent that the petitioner should furnish the cash security and indemnity bond to the extent indemnity bond of rupees 1 lakh, while releasing the vehicle in his favor. Also, he has also to be he has the other conditions as imposed by the trial court remain unaltered.
Your lordship waive out the cash security. Cash security waive out the cash security.
Cash security छाड़ देगी बाकी सब
आगे,
same. ठीक है.
One thing, my lord. Your lordship is saying super there. What is that meaning?
That is a word used everywhere. Except
Yes,
here.
we have no.
Superdama means you have to give Jimanam. That word is also used, prevalent everywhere in North India and all.
Not the, in Orissa.
Jimanama or Superdama? You just
Same.
take it up. Both same.
Obviously.
Jimanama karo.
ଜାଣିପାରିବେନି
Superdgi means entrustment.
Yes, yes. Super there.
Huh.
It is a perhaps Hindi language.
That is a Urdu word used from British period.
Right.
Like Dasti. Dasti is not
Dasti.
in English word.
No, Dasti is not English.
That is again a Urdu word.
Urdu.
Likewise, this is also a Urdu. Jimanama is
Jima
also Urdu
also,
word.
my lord, it's a
Urdu
not
word.
English word.
Yes. Dispose of. Yes.
Item 10.
1 week after
1 week. Yes. 2 weeks. Karo.
Item 11.
May I please? And then there is 2 items, sub-item and also the present.
There are 2 items.
My lord, the same petitioner.
Yes.
The present first one is the outcome from the sub-item. But in the present CRL is 3102 of 23. The petitioner is before Rasi for the direction for passing of the order dated 22 to 23 passed by the learned Atmalik for not giving no objection to the petitioner to avail the passport, my lord. Before the present one, the earlier also the learned trial court has allowed the
Permission in favor of the petitioner for renewal of his passport. So in order to
even though the
travel
learned
UK, London. What is the offense?
offense, my lord, matrimonial that has been amicably settled. For that reason, the sub-item has been filed. Both the parties have settled the dispute before the London court below, and the wife has received alimony amount. For that reason, the petition has filed the CRL, the sub-item 3172 of 19. There was a stay, but stay of further proceeding. But after
You have settled now. What stay? You quash it.
I have filed that for quashing of the matter.
We call them quash it, and so that this order also eventually go.
My lord.
Both the
both the
things
cases will dispose of
No,
both
my
the
lord.
petitions will be.
Now what happens, my lord? The opposite part in 317 to 19, the OP2
Okay, sir.
3172.
3172. That the OP, the notice served, everything was, but the OP2 was not coming to the court.
Why?
After taking the money, where he resides, I have, my lord, the noting, there is a noting. I have filed a IA for paper publication.
Your divorce is granted.
Drivers granted. She has taken all the money.
Show me the service report.
My lord. My lord, one thing I pray, my lord. The 3172, my lord, may peruse.
I say that's what I'm seeing.
The
Let us see the stamp report. Let us see. Sorry. Let us see. What is the service? What is the service report? Just see. And take it. Service report in
No,
3172.
my lord, again, pardon, my lord. Again, I have filed in 24/1/23.
Let us see. If the service is sufficient, then we will proceed.
No, service is not sufficient, my lord.
Why?
Are they staying out of session?
My lord. As per the direction of
Slender.
this honorable court,
Has returned to the sender.
again I have filed.
Correct address you have sent it. You have sent it in the correct address.
My lord.
This is the address.
My
Let
lord.
us see.
The address in the, my lord, page 14 of my CRNC number 317219. That address is that where the mutual divorce was allowed.
Who is the Devdas, it is Swagat, Anand, Devdas, Vinita, and
Maheshwata Sarangi.
Maheshwata Sarangi.
My lord.
Okay.
That address I had given in my petition, my lord.
Atmalik.
My lord.
Good.
Thereafter, the,
Now where is mutual divorce?
my lord, page 15, my lord.
15.
15, my lord, the judgment. And my lord, 25 is deposition.
What is this page 14?
Page 14, my lord. That should decision in the original suit, man. That should have been suit. With the for page 15 that is judgment. It address it.
13B petition.
19 is the order. The petition filed by petition for divorce by mutual consent is allowed. The marriage between the parties held in between them on ethic is hereby.
Where is the terms of condition? All the petition was supposed to be.
My lord, my lord.
Where is that?
That is my lord, page 20. My lord, kindly come to page 25.
25. Okay.
My lord. I have filed my exemption sheet in the form of affidavit which is written as per the instruction, and I have put my signature there on. After it was read over and explained to me, and I have to correct. I have filed an acknowledgement to the demand draft duly. I have received marked as exhibit.
10 lakh you received.
I have filed one joint move of a settlement.
That,
Thereafter, on cross-examination, I have received all the area maintenance amount from the petitioner too. We have mutually settled our dispute. Exhibit 2 has been scribed to my knowledge and education. I have received my permanent alimony to the sum of rupees 20
where
lakh.
does he say that as per the understanding we will I will not press all the petitions, and where does it say? Was not that a part of settlement?
My lord.
Where is that? In the affidavit she doesn't say that I will withdraw all the cases pending against each other or something like that.
My lord, memo for settlement.
Where is that memo?
29, page 29.
29.
9.
29.
All the proceedings pending in between the parties in various courts will be
Yes,
withdrawn.
This is the memo of settlement. Huh? Okay.
Both parties will not also file any further proceeding in any court. There.
Where is that? This which paragraph?
My lord,
Both the parties will file 13B. Where is that?
my
On the
lord,
copy of
I,
the permanent alimony. Both the parties will not file further proceeding in any other court of law. All the proceeding pending between the parties in the various courts will be withdrawn. Accordingly, the first party wife will file not press memo number so and so by SDGM Atmalik, and the second party husband will also file a petition to withdraw for MAT case number so and so. You have already withdrawn?
I have already withdrawn.
What is this case? SDJM Atmalik, the same?
it is that criminal
D-
proceeding
D-
matter.
DB case এটা
DB
So
case
DB case ସେ ସବୁ withdraw ହେଇଯାଇଛି।
ଆଉ ଏଇଟା କଣ ଅଛି 498
ଏଇଟା 490
490 ଉପରେ କିଛି ଲେଖି ନାହାନ୍ତି ଏଥିରେ
all the ଲେଖିଲେ ଆଉ
ନହେଲେ ଲେଖି
all the
ନାହାନ୍ତି।
proceedings pending
ଏଇ ଦିଟା
in
specific
various
ଲେଖା ହେଲା,
courts
ସେଇଟା
will be
ଲେଖା ହେଇନି।
withdrawn
ଏଇଟା ସ୍ପେସିଫିକ ଲେଖିଲେ ଏଇଟା ଲେଖିଲେନି।
specific କିଛି ନା affidavit ବି ଲେଖା ହେଇନି what is this
ହଁ
madam,
affidavit ଟା
What
ଲେଖିଲେ
drafting?
ସେଠି ଆଉ ଲୋଅର କୋର୍ଟରେ ସେ ତାଙ୍କର କଣ ଆଉ all the proceedings ଲେଖିଛନ୍ତି ଆଉ ସେଠି ପରମାନେଣ୍ଟ ଆଲିମନି ପାର୍ଟ ଟା ବି ଲେଖା ହେଇଛି ସେଠି
ପୁରା ଆଇଏ ଫାଇଲ କରିଛନ୍ତି ଫ୍ଲାଗ ବି seeking permission for paper publication।
ହଁ
ଆଇଏ ଆଉ ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି
ହଁ
ଆଇଏ
flag A ରେ
my lord flag B
ହଁ
flag B
what is this
767
ନୋଟିସ ଫାଇଲ କଲି
for seeking permission for paper publication।
see the practical difficulty she has taken the money
my lord
mutual divorce has already taken place she is not taking interest as simple as
and interestingly 11 witnesses examined in this case present case GR
and
case
you allowed 11 witnesses to examine
further proceeding by the stay was granted by this honorable court after
no, 11 witnesses are examined before the
trial
settlement.
court
No, before the settlement took place na
before the
when after the settlement how many witnesses are examined just check it out and tell me I'll cross both the things
Well.
we will not wait like this you tell me
after taking the money
that's right but the only problem is
11 witness examined whether she is examined in this presentation that is my lord if she is examined and her evidence will be taken into
where is
consideration and
the
question
FIR?
यही तो इट सेक्शन मना कर देता हूँ देखिए दे सर कॉपी दा
write down 3172 ଆପଣ ଆୟୁ କୁ କୁହନ୍ତୁ ସର୍ଭିସ କରିକି ରିପୋର୍ଟ ଦो
ଆଜ୍ଞା
I'll put it IO and if the IO says then we will pass it we last attempt through IO service through IO ठीक है because this is an FIR and settlement has already taken place write down 3172 second one write down this by way of this petition petitioner is seeking thing of the FIR number PSK start so and so लिख दो page 7 so ठीक है the land council for the petitioner submits that the present case is arising out of a matrimonial dispute so sir parties to the dispute have settled amicably out of amicably and the memorandum of settlement dated sorry date we need memorandum of settlement dated 30th August 2019 along with the affidavit of the parties have been placed on record on the basis of mutual on the basis of the settlement the parties have applied for divorce under section 13B of Hindu Marriage Act and the learned family court and the civil judge Malik by this order dated 21/9/2019 have been pleased to grant pleased to grant the mutual divorce. Also, the petitioner has also paid the permanent alimony of rupees 10 lakhs as agreed. Also, all other proceedings pending against each other stands withdrawn pursuant to the settlement, except the present one. Also, the petitioner has been trying to serve the opposite party number two, insofar as the present petition is concerned. however, could not succeed as she has left the given address. Given address. So in these facts and circumstances, the IO of the case, PS case number so and so, is directed to serve the copy of this petition to the opposite party number 2 and intimate the next date of hearing. Also, the IO is directed to file a status report regarding the progress of the trial in the instant case by next date of hearing. Date they do, give it on 18th.
Well,
Then comes for the petition is directed to supply a additional set of paper book to the counsel for the state, who shall transmit the same to the IO of the case. Copy good diyantu se transmit kardeve and author ratio status paijyo or class kardo detail cost
my lord, permanent alimony 20 lakhs, my lord.
20 lakhs you pay.
Permanent alimony 20 lakhs se receive karichi.
20 lakhs 10 lakhs 20 okay okay.
Okay.
18th you should give a
Set.
full set to him and he'll transmit it to the IO. IO will give a report on the basis we will quasi. Take it.
Item 12.
May I please also
Yes.
petitioner in this petition challenges the FIR, files this petition for
You
quashing
use mic. Yes.
petitioner filed this petition for quashing of FIR registered as Andhapur PS case number 83 of 21/4/2021 for the offense under section 341, 323, 294, 506, 354
Yes.
C
Yes.
and 34 I2C.
Hmm.
Here the informant also wants to compromise the matter. I have made a party to that informant.
Has he filed any settlement or anything of that
For the
sort?
first time, this matter has been
I need
lifted.
to
before
notice to
the
the opposite party
Your
number 2.
Lordship.
Opposite Mr. Dagada waives notice. Opposite party number 1 to come up on next.
Obliged. Your Lordship.
Next.
Item 13.
I prefer not raise.
Not press.
Hello.
13.
Item 14.
May
Yes.
file a petition for challenging the covenants order of proceedings under section 138 of NA. Under
138.
130. Under annex 5. Also have a glance. As per complaint petition, there is a dealings with the present petitioner and the opposite petitioner 2. Opposite petitioner of the dealer and the present petitioner is the one of the company. And they are dealing with the business under of e-bikes, 2-wheeler and 3-wheeler. In that case, in the meantime, due to non-fulfillment of criteria, the agreement was cancelled. Dealership was cancelled on the approach of the opposite petitioner 2, and that also accepted by the petitioner. And in the meantime, on the letter, the petitioner stated that your deposited amount will be refunded within meantime. And in the meantime, he has paid 8,34,752 rupees for dealing with the business. And in the meantime, one check was issued on 22/10/2022.
22. When the settlement? Settlement dated?
Settlement dated. Agreement was. Agreement.
Yes.
Settlement dated 25/5/2022.
25/5/2022.
2022.
Yes. Letter dated?
Letter dated 17/7/2022.
Check dated?
Regarding closing of dealership. Regarding closing of dealership.
Yes. Closing. Yes.
And
Next. Check dated?
Check dated 22/10/2022.
Yes.
Madam,
What is the, where is the, show me the legal notice.
legal notice, I have not annexed, my lord. The complaint petition is there. And I have
What,
annexed
show me the complaint petition.
Madam. Complaint petition.
What do they say regarding the issuance of the check? Towards what?
My lord.
Towards what you have issued the check?
Another thing, one thing, my lord. Under Annexure 4 series, I have paid after issuance
You
of
might
check.
have paid, that's a different story. That will be, you know, what you call, maybe towards the dealer running bill and all. I'm not on that. I just wanted to know the check was issued subsequent to your settlement.
Madam,
What is the narration given in the complaint regarding the issuance of check? Towards what you have paid?
after issuance of a check, I'll just have coming, it's one thing, madam. After issuance of coming check on 28/10/2022, check was issued, prior to that, check was issued on the basis of, say, I will refund all the amount and you will return the check on the compromise of the both the parties. And in the meantime, 18/10/2022 and 2/11/2022, in two dates, I have paid 2,24,000.
But he has not returned the check and
He have not
and
returned the check and
you-
suppressing the
what
fact.
action you have taken? Have you, you should have filed a criminal case against him, cheating.
No. He has bounced the check entire on the for the entire amount. Without by suppressing this fact that he has received the amount. And he also suppressed the fact before the trial court that he has received the amount and
So therefore, I am saying, where is the legal notice? Is the precondition for 138 is a statutory notice. In the statutory notice, have you said all these things?
yes, madam.
Where is that answer to the statutory notice?
Statutory
Reply to
notice-
the statutory.
Reply to the.
Reply.
Who is it?
Yes, madam.
That's the basic document for quashing. Because that is the statute provides that for before filing a complaint under 138, prerequisite is a notice.
Yes,
In the notice you have might have replied. In the all these things, have you said in the notice?
yes, madam.
If you have said, it's all right. If you have not said, then presumption operate against you and you have faced the trial. You show me the reply. If you have taken those stands in the reply, if the trial court doesn't take into consideration that and to cognizance, then you have a case for
Yes.
quashing. If you have not answered in the legal notice, then presumption operates against you and you have to face the trial. This is the settled principle of law.
1 week after the
1 week after. File everything I want to see.
Okay.
Next. And read 139 also.
Yes, madam.
Yes.
18. 15.
Please, your lordship. The order of cognizance as page 19.
Yes.
Under annexure 3 is under challenge.
Yes.
The arising out of complaint case. Arising out of complaint case.
Yes.
There are two accused persons. Right.
2%.
Two accused persons. Against one accused and two, the cognizance has been quashed because there is no material reveals from the evidence recorded as per the cognizance 294, 506 and there. The lordship make a
It is quashed.
quashed.
The
Qua
accused Purnachandra Sahu.
Purnachandra Sahu.
You are Vijay Kumar.
Vijay.
Bhuyan.
The
What is the allegation? What is the
allegation in complaint basically the outcome of a civil dispute. Civil dispute is pending. The husband of the present complainant filed a petition for a declaration that he should be declared as the
of the statement of the complainant is that there are absolutely no allegations whatsoever against the present, even for the offense of.
How confusing.
Show me the complaint.
the complaint.
It has been quashed by the coordinate bench only
And
because
yes,
there is no allegation against.
Here
that.
is the similar the evidence is the annexure to the evidence.
No,
the
complaint just see.
complaint
There is
case
arising out of complaint.
page 12 started from page 12. When page 11 relevant started
Yes,
page
yes,
12.
yes, yes.
that the complainant husband Ajay Bhuya is the elder brother residing outside the native village. Accused is the younger brother, the present petitioner. After the joint
Now, where are
family
you reading? 7, para 7.
Romanic 2, page 12,
Yes,
Roman 2.
yes. The
That the
complainant
complainant
husband
husband
is the elder brother.
is the elder brother residing outside the neighborhood. Since childhood he is residing outside and identified as son of some X. The accused is the younger brother of the looking after the joint family property affairs after death of the father. The ancestral homestead land is not sufficient to the accommodate both the family, for which complainant's husband purchased land at Hajipur and sometimes residing there, taking the advantage of the complainant husband absent in the Sankarisai village. The accused person chalking out plan and prepare the fraudulent document subsequent thereto, utilizing the said fraud document, grab the complainant's father-in-law property and recorded in the name of the alone. The accused number 2 equally liable to prepare the fraudulent document and appropriating the complainant's husband's property. Both the accused person were signed the names of witnesses without obtaining the signature statement such and such, for which they are equally liable to be punished 463, 465. The above fact behind the knowledge of the complainant, when the complainant husband knew about the same from the public after obtaining the certified of the fraudulent documents. Fraudulent documents, a mutation appeal is pending now, sub judice before the Honorable Court. Suit is also filed for a declaration. He is to be declared as son of Birokishore. The father is present.
Protest before the
The accused at the joint homestead land, Sankarisai village, such and
You are
such.
accused number 2.
One.
One.
I am the elder brother, younger brother.
Okay. Joint homestead.
Such and such, the just statement they are saying, but then your lordship may kind of glance the evidence recorded.
There is a, see, 5 is the specific allegation
Yes,
against
no,
accused
evidence
number
may
1.
kind of glance. Evidence, what evidence has been laid.
You are the
Complete
accused number 1.
Yes.
So that is the reason the High Court has quashed accused number 2.
Two.
Because there is no allegation.
Then evidence recorded. Evidence, page 15, annexure 2.
Evidence what? 161.
The initial statement recorded by the
Those things I will not.
arising out of civil dispute, your lordship. The Honorable Supreme Court has given a judgment to that effect, lordship. The Katmadi clock was a criminal case. Lordship, make evidence page 15. What is the statement?
It's a case arising out of complaint.
Complaint.
And there is a specific allegation against you. Whereas
yeah.
there is no allegation against the accused number 2.
No, there allegation accused number 2
Accused
that
number
he
two.
prepared the document and for
Document is there, but see, insofar as this, see, what is the offense? Offense is 294 and 506. Insofar as 294 and 506 is concerned, insofar as this accused number 2 is
No, lordship, make
One.
kind of deposition.
one is
That I am
there
not
is no
aware.
allegation.
Yes, the deposition may kindly have glance. What
Person also.
offense is made out? Deposition, even the complaint. Page 15.
15.
Huh.
Okay.
I am the complainant in this case.
1 minute.
Relevant is para 2.
1 minute. At this 1 minute. Let me reach there. Okay. 15. Yes.
Para 2.
I am the complainant.
I am
Of
the
the
complainant in the case. I have filed the case against the Vijay Bhuya and Purnachandra Sahu. The occurrence took place such and such house at Sankarisai. Sankarisai, Hajipur, near about 5 kilometers difference. On the alleged date of occurrence, I alone with my husband has gone to the house of the brother-in-law, the present accused, and asked about the forgery document where he was trying to grab all the properties, my properties. Then my husband was silently watching him and the innocent man. He was a serving agent CISF.
Then Vijay Bhuya went
Then
to the-
Bhuja went to the house and brought a kotari, housing the kotari that threatens to, only threatens. Only 294 is there. 294, 506 is
No.
there.
I will not pass because it write down.
And submission that I'm
Right.
because arising out a civil dispute. That's why I played.
That's a part, but there is a
Usha
complaint.
Chakrabarti and the state of West Bengal.
Maybe, but this is what says the complaint is there.
That he has prepared because admittedly, my lord, the present husband of the present complainant was the son of
You have come against the cognizance order.
cognizance. Son of the Brahmaravar Bhuya. Yes, in the school register, his name is father of Brahmaravar Bhuya. In the serving has more than 32 years as a servant and retired after he getting pension from that. Now taking
And the
out
cognizance is only taken under
294,
294, 506,
506.
34.
Yes. 294 is not, no whisper in the evidence, my lord. What, no whisper. And 506 is not only threatened to Kottari. There is no threat.
It is very threshold. You can agitate the issue at the appropriate stage.
Your lordship knows that I have no objection, but this type of allegations on the basis of that civil suit is pending since long at the behest of the husband of the present. complainant.
This order is creating problem for you.
No, I'm just why I'm so, because if I would not have disclosed that, it would
No,
have something else.
obviously,
That on purpose, but I am not.
It is your duty to
Do it, yes.
disclose, but this order is very specific. It says
No,
that
I'm not
insofar as
disputing
this
that.
accused
Why?
is concerned, there is
No,
none.
that's why there are two accused that, but not that. But my humble submission.
Otherwise, the entire cognizance order would have been quashed.
No, why should I? Once there is a order, why should I suppress to that?
No, that's right. You are right.
Because
That's the duty of.
entire contents of the complaint arising out of that the civil dispute. There is a family properties dispute. He has taken, they are staying somewhere else, I am staying somewhere else. I am staying all through the Bhubaneswar along with my daughters. I am not residing there. They are staying in Hajipur in more than 6 kilometers away.
Right now. The present petition is directed against an order dated 18/6/2019, by which the learned SDJM Jagat Singhpur have taken cognizance of offence under section 294 or 506 34 IPC on the complaint case filed by opposite party number 2. There are two accused, namely the petitioner and one Purna Chandra Sahu. Full stop. At an earlier occasion, the co-accused Purna Chandra Sahu filed CRLMC number 115 of 2020 before this court. The coordinate bench by the order dated 21/4/2023 have been pleased to allow the said petition passing the proceeding vis-a-vis the said petitioner alone. The relevant part of the order dated 21/4/2023 reads as under para 1, 2, 3. It's very specifically what used is, just see, the said order is accordingly hereby quashed vis-a-vis the present petitioner alone.
Hello.
That is the problem. Yeah. 3. Full stop. The perusal of the aforementioned order indicates that the prosecution, the complaint has been quashed, the co-accused, because in the complaint there is no specific allegation. However, perusal of the complaint at para, para 5 indicates that there is specific allegation made against the present petitioner. Therefore, at the stage of cognizance, this court is not exercising the jurisdiction under section 482 CRPC. However, all the contention raised by the petitioner at this stage are available to him to raise at the appropriate stage under on the basis of the said observation, the petition is disposed of. Next, 17.
The opportunity raised at the appropriate time.
Opportunity
Problem.
17, 16. Yes.
16, may I please, your lordship? This petition has been filed for quashing of those criminal proceedings on the ground that the matter has been amicably settled between the parties.
What is the offense?
This offense 376, but in the meantime, both the informant and the accused person, they got married and they're living as husband and wife. Also, they got their marriage.
Both of them are major.
Yes, major. They got married and the registered certificate, marriage certificate is also there. I have filed.
What do you say?
Yes. 25 years, victim is 25 years, accused is 27.
Where is it?
Marriage certificate is taking. Marriage certificate is not there with me. Marriage certificate.
You have marriage certificate.
Yes, yes. The original certificate also Xerox copy.
Where is the informant at the cost of jeopardizing their marital life? Hence, this court is of the considered view that this is a fit case for quashing police. Accordingly, FIR number so and so stands quashed. Stands quashed. This we are record रखी थी.
So रखे.
Marriage certificate. Photocopy check लिख दो. Original of the marriage certificate is seen and returned. A photocopy is placed on record.
Item 17.
Madam, here in this case, the petitioners, they pray before your lordship for quashing of the case on the ground that it has been mutually settled. And my lord, the opposite party number 2 informant, as well as the petitioners, they all are present in the district court campus in Sundargarh, my lord, today. And if your lordship will direct,
All of them are there.
all of them.
What is the offense?
My lord, offense is 365, 341, 323, 294, 354, 506 by 24 by 50. That is section 3 of ST and SC, Prevention of Atrocity Act.
What is the impediment?
Both parties they agree.
There is
People
no-
also will indulge. No, there is no comparable offenses is there. But if the
No, compoundable, but is there any legal impediment?
no. In 480, lordship can exercise.
SC can be
Many
quashed. Your lordship.
cases, my lord,
in
There are
connection with
decisions
the
of
cases.
this one court also. SC.
That lady is appearing
yes,
and we see, where is the IO? How can, how many accused are there?
my lord, 6 petitioners.
No, who will identify them?
My lord, if your lordship will direct the registry of Sundargarh district before register honorable Court of Sessions, who is in charge of that case, will deputy a person to identify. If your lordship, otherwise they will give an advocate here and they can. ସେଠି କିଏ advocate ମାନେ ଅଛନ୍ତି ଦେଖାଯାଉ.
You also belongs to, all are the accused or what? Who is the informant?
Informant, my lord,
Damayanti?
is present in virtual mode. She is. Damayanti Khamari. Damayanti Khamari କିଏ ଅଛନ୍ତି ସେଠି?
IO is there.
My lord, IO is not there because the case has been placed, charge sheet has been placed, IO is not there. And as per my instruction that your case is posted to today, they have voluntarily come to the district court.
Don't worry.
Your lordship may ask them regarding their. Your lordship may ask.
The
that-
complainant is there, your lordship acts.
Your lordship may ask and if satisfied, then
And the complainant is there, but her
one advocate is there, my lord.
advocate is there, but the what you call Aadhaar card and all, she can't place it on
My
record.
lord,
No?
they are one of
She's
the
holding, but
My
how can
lord.
she place it on record?
That
Another
You
date
have
will-
their Aadhaar
Another
card.
date.
My lord,
Another date your lordship may fix up so that they will produce
Now
the
what
other
I'll
card.
do is let them go and produce everything before IO.
Before I go.
Yes.
Before IO.
Including the joint affidavit also.
Joint affidavit.
Yes, yes.
Full service.
I will send it to this.
By way of the present petition, the petitioner seeks to the petitioners, there are no, write down like there are how many petitioners? There are
6 petitioners.
as many as 6 petitioners in the present petition. Full stop. They have invoked the jurisdiction of this court under section 482 CRPC, seeking quashing of GR case number so and so. Full stop. Full stop. The GR case number so and so, GR case as mentioned above, came to be registered at the instance of the opposite party number 2. Opposite party number 2. Full stop. The land counsel for the petitioner states that the parties to this dispute have entered into an amicable settlement. Amicable settlement. Full stop. the accused persons, namely the petitioner and the opposite party number 2, have appeared before this court through virtual mode, full stop. That lady's name, MS so and so. What is the name of the?
Comment.
No, I am talking about the lady lawyer. Yes, ma'am. What is your name? Yes, yes. What is your name, ma'am?
Nirupama.
Nirupama? MS Nirupama Sahu is appearing through virtual mode from Sundargarh, along with the opposite party number 2 and the petitioners. And reiterates the stand taken by the petitioner, land counsel for the petitioner. Full stop. Next one. Having heard the parties and the land counsel for the state, it is directed that the parties may present with their identity before the IO of the IO before the
Talsara PS.
Before the Talsara PS, huh?
Yes.
Talsara PS. Talsara PS. The parties may file a joint affidavit before the IO.
Yes.
Before the IO, along with their identity card, huh? Along with their identity.
Yes.
Full stop. The IO, after collecting the joint affidavit and the identity, may transmit the same to the land counsel for the state,
Yes.
who shall produce the same before this court by next date appearing on 17th.
70.
आज ये पठेई दियंतु आज ये पठेई सब कर देबे अछंती समस्त जाकी संगे संगे कर देबे पास कर दो नेक्स्ट टाइम ठीक है इट इज सेफर फॉर ऑल ऑफ अस
Yes, Your Lord.
डू इट नेक्स्ट
Item 18.
May I please, your lord, my lord, the petitioner was earlier on page, lordship kindly see page 11. The offence is under NDPS Act 11 kg, that is below commercial quantity. But the bail, my lord, is jumped, my lord, on 25/3/2021, my lord, NBW issue, my lord, page 15.
when was the bail?
My lord, he was released on bail on 9/5/17, my lord,
17.
page 11.
And thereafter you didn't appear?
On 21, my lord. 25.
No, thereafter have you appeared?
Yes, my lord. In all the date, my lord, the petitioner appeared, my lord. But on 25, my lord, 25.
And where is the order?
That entire order, my lord, I have not filed, my lord.
Okay, but this is an isolated incident of not appearing, or?
No, my lord. On that day, my lord,
habitual?
he has not. You lordship kindly see the order, my lord.
That
The case record is put.
25/3/2021.
My lord.
Yes.
The accused is absent. No step on his behalf is either taken by the Law and Defense Council or for the accused. The bailer or for the accused also failed to their duty in ensuring the attendance of accused in court today. No PU, no PW, issue NBW against the accused and notice to him.
Tara hearing record is put up today through the book Defense Council to file bond as per the order dated so and so. Bond तापर तो किसी ही नहीं होते लगी.
My lord.
Yes.
Issue release order be there.
That is
11/5/2017.
11/5.
Granted bail.
17 granted bail. Thereafter absconded. Absconded. There is no hearing to them.
Yes.
All of it are in one
My
hearing. Right up. The petitioner is an accused. Accused in case FIR number so and so. Huh? So. He was enlarged on bail on
9/5/17.
9/5/70.
And the release on
9/5/70.
11/5/17.
9/5/70.
And the release on 11/5.
And the 9/5/70. By way of the impugned order dated 25/3/2021, the trial court has now issued NBW bracket A against the accused since he failed to appear before the trial court. Perusal of the record indicates that previously on 11/5/2017, the petitioner furnished the bail bond pursuant to the bail order granted in his favor, and he was then lodged on bail. Thereafter, when the matter was taken up on 25/3/2021, he was absent. Therefore, the NBW was issued. Full stop. Next one. Having considered the facts and circumstances of the present case, the order dated 25/3/2021 set aside with the direction to the petitioner to appear before the court. As and when the court requires his presence as per the terms of the bail order dated
That is 9/5/17.
9/5/17. The subsequent failure to appear in the court will be not condoned.
Right.
Not condoned. Okay. Next one. Yes, next. Dispose of this.
19.
Yes.
Against the order of rejection, my lord, 311 petition of the petitioner at annexure 3, my lord.
3. Okay.
My lord. Now, you may see page 16, the order portion.
Yes. 311.
My lord.
PW2.
Yes, my lord.
Have you cross-examined?
My lord, she has been cross-examined. However, lordship, I have a glance to see the annexure 2.
Yes. Compromise.
Yes. The father of the victim made compromise. Lordship, with this petitioner,
After the cross-examination, that is on
No, prior to.
4/11/16.
My lord, FIR has been lodged on 2018 at the age of 20. Lordship, I have a glance to page 7.
What is the offense? POCSO.
Offense, POCSO. POCSO is not, in fact, POCSO is not matter of the lordship. I have a glance to the page 7.
7, huh?
My lord.
Okay.
There is law of affairs between the two and this petitioner. Yes, lordship, let's see page 7. Mu etalakari Swarnamyee Das alias Lija, boyes of 20 years. Pita Sanjay Das. My lord, Sanjay Das, the compromise has been signed with this petitioner. Annexure 2, lordship, have a glance to that. Sanjay Das and it was before.
Victim is Lija.
Lija, yes.
He's
Lija
20 years.
Swarnamyee Das.
Huh?
Lija alias Swarnamyee Das.
20 years.
Yes. At the age of 20, 4 years back, she has been raped. That is the allegation.
Okay. Sanjay Kumar Das
is the father.
Is the father.
Yes. Cause of action arose on 4/11/2016, so far as annexure 2 is concerned, your lordship. Page 12. To the inspector in charge of Nemal police, at post before the police station, this compromise has been made between father of the victim and this petitioner. Lordship may see that.
Yes.
And what are the, my lord, conditions?
That is Faisala Patro.
Yes.
Dated
in 2016. Then FIR was lodged 2018. Alleging that 4 years back, the petitioner has raped the petitioner, raped the OP number 2.
What is the Faisala?
Faisala, yes. 4/11 तारीखरे, may I read your lordship? 11 प्रथम पक्ष the father of the victim विरुद्ध करिଥିବା ଏକ ଅଭିଯୋଗ ପତ୍ରର ସ୍ଥାୟୀ ସମାଧାନ ନିମନ୍ତେ ଆଜ ଦିନ 4/11/2016 ତାରିଖ ରାତ୍ର ପ୍ରାୟ 7 ଘଣ୍ଟିଆ ସମୟରେ ଉଭୟ ପକ୍ଷଙ୍କ ଉପସ୍ଥିତିରେ ଏକ ଭଦ୍ର ବ୍ୟକ୍ତିମାନଙ୍କ
ଉପସ୍ଥିତିରେ
ସ୍ଥାନୀୟ ନେମାଳ ଥାନା ପରିସର ମଧ୍ୟରେ ନିର୍ଣ୍ଣିତ ପ୍ରସ୍ତାବ ଫଇସଲା ସମ୍ପାଦନ କରାଗଲା। ପ୍ରଥମ ପ୍ରସ୍ତାବ
ଆଜି ଦିନ ଠାରୁ
ତାର ଦ୍ୱିତୀୟ ପକ୍ଷ means this petition ଝିଅର ନାମ ସ୍ୱର୍ଣ୍ଣମୟୀ ଦାସକୁ କୌଣସି ପ୍ରକାର ଖରାପ ବ୍ୟବହାର ପ୍ରଦର୍ଶନ କରିବେ ନାହିଁ, ତାଙ୍କୁ ମଧ୍ୟ ଫୋନ ମାଧ୍ୟମରେ ଯୋଗାଯୋଗ କରିବାକୁ ଚେଷ୍ଟା କରିବେନି। ଦେନ୍ 2 ହେଲା ଏଇ ଦ୍ୱିତୀୟ ପକ୍ଷ ପ୍ରଥମ ପକ୍ଷ ଝିଅ ସହିତ କୌଣସି ପ୍ରକାର ସମ୍ପର୍କ ରଖିବାକୁ ଚେଷ୍ଟା କରିବେ ନାହିଁ କି ସ୍ୱର୍ଣ୍ଣମୟୀ ଦାସଙ୍କର କୌଣସି
प्रकार किछि क्षति ହେଲା भले कार्य करियोनी देन थर्ड प्रपोजल प्रथम पक्ष द्वितीय पक्ष प्रथम पक्षଙ୍କର ଅନ୍ୟାନ୍ୟ ପରିବାରର ସଦସ୍ୟ ମାନଙ୍କ ପ୍ରତି କୌଣସି ପ୍ରକାରର ଅପ୍ରୀତିକର ପରିସ୍ଥିତି ସୃଷ୍ଟି କରିବେ ନାହିଁ.
Don't you think that this settlement is going
Yes.
against you?
In 2016
Going against you.
मतलब
It is going against you.
Hajur,
The
there
fact
is a law of affection. What
but
happened?
whatever, but
I am coming to the affair, Your Lordship.
see, the FIR is
No, all right. That was
the
a
fact
compromise.
that in 2016 something happened
Yes, that is
is
true.
now
My Lord,
on record.
both the victim and the petitioner, they are fail in law for last 4.
Maybe because 16 years. That time 16 years.
ସେତେବେଳକୁ ସାର୍ 16 ବେଳକୁ ବି ତାକୁ ହେଲାଣି 18 years.
But then the
But then FIR was lodged in
FIR is
2000
in 20. It
No.
says 20 years.
Yes. 16 ବେଳକୁ ତାକୁ କେତେ ବଡ 18 ବର୍ଷ ହେଲା. That is
Thank you.
16 that is an allegation against me.
2020 ରେ FIR. ଠିକ
Yes,
ଅଛି?
my Lord.
ସେତେବେଳକୁ କହୁଛି ମତେ 20 ବର୍ଷ ହେଲା।
ହଁ 20 ବର୍ଷ
16 ରେ କେତେ ହେଇଥିବ ତାକୁ?
16.
16 ବର୍ଷ।
Yes.
ତାହେଲେ ସେଇଟା ତ ଆପଣ ସେଟଲମେଣ୍ଟ କରିକି you are proving the fact that yes there was something.
Sir, there is
The
law of
offense
affection
is-
that
offense is- agar if that settlement would not have been there,
Yes.
the benefit of doubt you could have created,
my Lord, that
saying that I have not done anything 4 years back.
ସେଥିରେ ସେ କଥା କହୁନାହାନ୍ତି ତ କମ୍ପ୍ରମାଇଜ କରୁଛି ତାକୁ ସେ ହଇରାଣ କରୁଥିଲା ଫୋନ କରୁଥିଲା
That's
that is there.
then what do you want now?
ନାଇଁ ସାର୍ 16 ବେଳକୁ ତାକୁ ହଉଛି 18 years.
But all these things okay, but
2016
311 ରେ କଣ relevance କାର?
ମାଇଲ
311 ର relevance
ଆମେ ତାର ଏଇ କମ୍ପ୍ରମାଇଜ ଉପରେ କ୍ୱେଶ୍ଚିନିୟର ବି ଦେଇଛୁ ହଜୁରଙ୍କ ପାଖରେ ବି କପି
କାହାକୁ?
ଦେଇଛୁ
Father,
କୋର୍ଟ that was rejected your
ନାଇଁ,
lordship
ନାଇଁ,
may see.
which witness you want to summon?
Only informant and his father.
Informant
And-
I'll not allow. There is a bar. Father I'll allow.
Father ଯିଏ ଆଜ୍ଞା
Because see, if at all there is an settlement, it is between father and you.
yes
Okay?
Yes.
So I will give one opportunity insofar as father is concerned. 33
and
5
then
bar.
my lord 67 so far my lord that should not be any bar because 2016 the victim was at the age of
This is subject
18
matter of it.
that is 18 20 ହଉଛି
But POXO is invoked,
my lord Pokso
and on the face of your settlement,
my lord
I am of the view that
POXO
there
is
is
not there.
something happened.
at that time that she was 18 years 2016 ତାକୁ
But the entire, I'll brought some facts on Lordship. The entire trial
There
is
are 161
unwarranted.
statement against you. There are allegations, specific allegations. The offense is under section 13(2), read with 13(1)(a) of PC Act and 409,
Lordship, there are offenses.
468,
I don't
120B,
deny- I don't
and
deny
everything you want in a
the
PC Act to be
allegation
quashed.
has been made. The allegation has been made against me, but that cannot.
That has to be tested in trial, man.
That has to be tested in trial, but there are certain
There
facts.
are materials on record which indicates your involvement. So
I'll-
at this stage,
Lordship, I'll point out certain facts. Lordship.
and this is arising out of a complaint before Lokayu.
Exactly, Lordship. Exactly, Lordship. There is no opportunity of hearing has been given to the petitioner. And solely basing upon the orders of a loci, the FIR has been registered and the charge sheet has been filed. In 2017, a Morum road construction work was undertaken. And petition number 1 was the assistant engineer. Petition number 2 was the junior engineer who prepared the estimation. Ultimately, the work was conducted. That was completed in 25/8/2016 itself, 17 itself, Your Lordship. In 2017, another work order was granted for plantation in both the side of that particular road, Your Lordship. In 2018, one super cyclone affected the area called Titli, Your Lordship. I have Annexure 6 series. I have
Italy has washed away everything which you have done.
Your Lordship, I have.
That is your defense.
Your Lordship,
I have done everything, but Italy has washed out everything. What can I do?
Absolutely.
That's what you mean to say.
Yes, Your Lordship.
That will be tested.
No, that has to be tested, but the court could have taken judicial notice of that fact, Your Lordship. And this order is a non-speaking order. And the petitioner number 3, Lordship, he joined much after the entire work was done, entire payment was done. How he could be an complete? Your Lordship?
He might have cleared the bills.
No, absolutely not. By the time he joined, Both the works were completed and
But
payments were done.
why all the accused have gone for quashing then? If you
But
think that he has a good case, he should have come first.
Bishop, I filed
By
a
joining with the other accused indicates that you are also in 120B.
No.
If you think that one accused has a good case, you should have tried his luck first.
I should have, Your Lordship. I
So
should have.
that's the mistake you have committed.
Yes.
Now
I
the
admit
trial
it.
court deals with the case in toto and says that all of them are involved.
No,
Then
the
you are gone.
petitioner number 3 stands on a different footing
Strategically, you are
altogether.
gone.
Strategically, I'm wrong, Your Lordship.
That's-
I admit, Your Lordship.
That's-
But since I have filed the.
It appears from the paragraph which from page 87, the only defense which you are raising is super cyclone.
There are two defenses, Your Lordship. The first thing is that they say there are two work orders. One is regarding the construction of work. The second is plantation.
These are the
Your Lordship,
Manrega payments
in
are made.
2017, we completed the road. And this is the scheme under the MGNREGS. The beneficiaries were paid through their bank account. They were verified. They admit that yes, they have executed the work and they have received the payment. Only because the vendor from whom we purchased the material, he has died in the meanwhile. We have been made to stand in the trial, Your Lordship. And thereafter, there are 75 MGNREGS beneficiaries. Out of those 75 beneficiaries, only 5 signatures did not match or they're not fit for the comparison. That weighed with the court below to state that we have manipulated the entire thing. We have not done anything, Your Lordship. And in 2017, the work was completed. In 2018, one cyclone. In 2019, the other cyclone, funny cyclone. Your Lordship knows the devastation made by both the cyclones, Your Lordship. And I have enclosed at Annexure 6 series, the report by the Special Relief Commissioner stating that the block affected and the particular roads washed away in the said cyclones, Your Lordship. However, ignoring everything, we have made as accused in the trial, Your Lordship.
That report which you have placed on record,
Yes, Your
the
Lordship.
cyclone Titli and Fani
Yes, Your
published, and does it cover your project?
Yes, Your Lordship.
Where is that?
Kindly. It's the
Annexure 6 you have
copy-
filed.
it's
Where is that?
page 90, Your Lordship. Kindly, I'll just take
990.
90, Your Lordship. I'll just take few.
90 is the design of the
No,
cover design of
but
the
it
report.
starts with
You show me in this project, in this report,
Is it-
whether the project you have been
Yes,
working is
exactly.
covered or not.
This-
If you have covered, then the defense provided by the God by way of Titli and all, you may get
This
something.
is not the defense, Your Lordship. Probably that made us accused just because it devastated the road and now we
Where
are
is
standing
that?
the
You
trial.
show me,
Your Lordship,
the project is also covered.
And then, Your Lordship,
I have been
the
searching
report has
that.
been made, taking into account all the devastation, that particular my project name may not be there, Your Lordship.
Then
I'll show you, Your Lordship, the block has affected and the roads are affected. Your Lordship, may kindly see.
generally everything is affected. But if your defense is because of this only, the entire work which we have done is washed out, you have to show from the
SRC cannot
show
be
from the report
expected.
that yes, this part of the
Yes,
project is washed away.
I'm conscious.
Then perhaps you may have some case. Otherwise, see, this general
Kindly-
statement needs
Yes,
to be proved on the.
I'll just take you to
basis
the,
of other material.
I'll just try to assist the
Yes,
Honorable Court,
yes.
Your Lordship. So I'll just repeat that there are two work. One is construction of Moro Road and the another is plantation of the roadside, Your Lordship. Your Lordship, may kindly see page 94 first. 94 is the report published by the Special Relief Commissioner regarding.
I've seen
cyclone
all
Moro.
these things. I've seen all.
Your Lordship, on
I'm
page
looking at that
94.
These are general statements.
No, these are not general statements, Your Lordship.
90.
Page 94.
Yes.
They say there is a landfall of about 145 per kilometer, Your Lordship. 145. Thereafter,
In which area? The area where
I'll
your
show you
project
the,
is there. Show me.
I'll show you the area, Your Lordship. And as Your Lordship knows, the Titli made its landfall regarding in the coastal district of Palasa and the Ganjam district, Your Lordship. It made its landfall between them, Your Lordship. Page 105, Your Lordship. Page 105 is the details of rainfall details. Page 106 is that concerns me, Your Lordship, district of Ganja. It shows there is a tabular form regarding the land.
Yes, Ganjam,
Yes,
Chhatarpur, Ganjam, Purushottampur,
Lordship,
Bhavishwari
22
Nagar.
blocks. 22 blocks of Ganjam was affected.
There must be some report generated in the block wise or the district level. This is a general report of the entire state.
I'll produce. Your Lordship,
If
grant
you
me
can,
some time.
from a particular block, if there is a report saying that this project are affected, then perhaps you may have some case. This general document you are filing, entire state, entire country, and entire this thing will not help you.
Your Lordship, grant me some time. I'll try to produce some documents.
Since you are trying hard, I am giving you time, but you don't have a case.
I'll try to.
Thing is that he has participated all along. He has participated in the Lokayukta proceeding.
No,
And he has been given opportunity. And after hearing both the sides, Lokayukta directed for investigation, and thereafter, after inquiry, that they given opportunity. Thereafter, FIR was registered. Thereafter, investigation was conducted. Even the
Departmental proceeding initiated against you?
No, Your Lordship. Absolutely not yet. That itself goes to show my innocence. Your Lordship.
No, department has given clearance. Department has given clearance to launch prosecution against the
There is
petitioner.
nothing on record to.
Without that,
source
cannot
Your
be.
Lordship. There is nothing on record to source.
Lokayukta first department को notice करती along with the accused.
Your Lordship, can you grant me some time? I'll try to produce.
Or
some
I'll
time.
expedite the trial and.
No, Your Lordship, grant me some time so that I can convince Your Lordship that to produce.
Okay, okay. See. Take it on 30th. 30th.
30. Much of it.
But you don't have a case from our side. But since you are trying that, let us try. We are ready. Let's try.
Much obliged.
But still, you just see the block level or
District level.
district
reports,
level reports are there.
Absolutely.
Which project is affected? But
Yes,
if
yes,
that
absolutely.
report you can place,
Yes.
They
on
said
record,
say
then we
block,
can think.
that block is not coming.
Let us see.
Do documents say the
I'll try to go through and produce whatever records
Yes,
I have.
yes, definitely.
Much obliged.
Yes. 21.
21.
Yes.
Great vigilance. Petitioner in the present case challenged the order of taking cognizance passed by Judicial Magistrate First Class Rimapada in taking cognizance of the offences and issuing summons against the petitioner under annexure
Page 20.
page 21. Annexure 2, page 21. This is a case parrot which squarely comes under the ambit and scope of the decision reported in AR 1992, Supreme Court 604, Vajalal versus State of Haryana. In the sense,
Civil case.
Pardon?
Civil case.
No, 604, that is a case with regards to quashing. Ballot.
And you want to say it is a civil
Yes,
issue.
civil case, and out outburst of the case which I have filed against them. They had gone anticipatory bail from this honorable court by paying the amount, depositing the amount ballot, and they are after that also they came with the present complaint ballot and where cognizance has been taken and
in your FIR.
Ballot. No, in their complaint case, they by FIR, they well in that affair under annexure C ballot machine.
Yes.
4.
4, huh?
Right.
Yes.
That is at page 25. I lost it.
You are the informant in this case.
Yes.
And what happened to this case?
That case is pending in which charge sheet has been submitted and
This was
offense under 420 minor. 420 by 34.
right.
As per the recitals,
No, this is the FIR dated.
dated minor
Uh,
2022.
6/10/22.
8/10.
Yeah.
8,
8, 10,
22.
22.
No, 310.
Anyway, 8, 3, whatever. Next, these are what are the offenses? 420, 34.
Well, let me see the recitals of the affair, then
Okay.
Mallet can understand the
Okay.
game which they are playing.
Yes.
I am an old ailing widow, one Ajay Kumar Raut, aged about 38 years, son of so and so. He is the friend of my son Rajkumar Mohanty, while my son working at SBI
We are
Baleshwar.
reading
Mallet page 27, affair.
20.
Affair lost by
Okay.
Padmini
Yes,
Mohanty.
yes.
Padmini Mohanty, Mallet is.
Sorry,
It's a number
I'm an
one.
old ailing widow. Yes.
Mallet. Again, man, I'm an old ailing widow, one Anjan Kumar Rao, aged about 38 years, son of Ramesh Chandra Rao, so and so. He is a friend of my son Rajkumar Mohanty. While my son working at SBI Baleshwar said Anjan Kumar Rao had taken one bank loan for his vehicle business. Since then, he had got friendship with my son and also comes to my house accordingly. Said Anjan Kumar Rao arranged one old Tata truck registration number so and so, which I had purchased on good faith. Thereafter, on 18/4/2022, I sold the same to said Anjan Kumar Raut by way of an agreement for a consideration amount of rupees 23 lakhs, and of which he paid 9 lakhs to me and gave 3 numbers of checks, so and so, so and so, so and so, respectively, towards payment of balance consideration amount. On 25/5/2022, I lost checks in my bank, named this SBI Nimapada branch, which were bounced due to insufficient funds. In spite of my repeated approach and request, Anjan Raut is not paying the aforesaid balance check amount. Further, recently I came to know that said Anjan Kumar Raut had committed certain frauds pertaining to chassis number and bottle of through aforesaid truck in order to cheat us, and where he is alleging against me to that effect. In this context, I have lost one affair through online, and on 28/5/2022, through speed post before the IIC Chowdiaganj PS.
What happened to this?
This case ballot, the 420/34. Again, what I want to say, but further I obviously submit.
Then 46 lakhs rupees she had cheated from you, father and all.
Yes.
This is the allegation.
Mallet.
Okay.
Then Mallet, with regards to bouncing of check, 2 complaint cases.
And there are you have given online FIR and this FIR and 138 proceedings. You have drawn against Anjanai.
Yes. Mallet, what is his case now?
Now, yes.
Yes.
Come
Come
to his case.
Mallet. The same case he has twisted.
Where is that?
That is called page 11.
Please 11.
I have also annexed the agreement which he has entered into.
Same truck.
Same agreement he has relied upon. I just twisted the facts.
Right.
The accused number 1 on 18th April 2022 made an agreement with the complainant to sold her vehicle, so and so, for total consideration amount of rupees 23 lakhs only, and she had taken 9 lakhs in advance by amount of transfer. The complaint known that the registration paper of vehicle was duplicate forged. So when the complainant told such things to the accused person,
this is your petition.
This is the complaint case where we have been taken as an accused. I draw Mallet's attention to the affair.
Page 11 is okay. This page 11, but page 11 is Padmini Mohanty again.
That's Padmini Mohanty, petition number 1.
This is the complaint given by you.
No, accused. The name and address of the description of the accused. Serial number 2, column number 2.
Acha. Okay.
That case which we had lost in the year 2022, he has just twisted the same fact. Everything.
I understand it now.
Mallet, everything will be clear.
Parite of the complaint.
Page 21, Mallet, this is the agreement. What was the agreement and what he
21.
is coming now with the case? 21.
Yes. That is it. Tata.
Anjan Raut and Padmini Mohanty agreement. That agreement which he is referring, I have also referred in my.
And the earlier affair.
Mallet.
Yes.
What is that agreement?
Yes, sir.
Complaint case notice asan suman.
For abundant precaution, we have made them a party, otherwise complainant is the main
The
party.
complaint case to not to inquiry cognizance needs.
Cognizance ନେଲେ ଟିକେ ଭାବିକି ନେବେ ନା ଏମିତି ନେବେ।
For that reason, I
That
was.
maybe it depends in his FIR. Another FIR for that.
Well, let them to say.
I'll stay this
Whatever,
proceeding.
yes.
I'll stay this complaint.
This is why I was drawing Bailer's attention to 92 Supreme Court 604. There are 7 guidelines.
This is apparent case.
Seven guidelines have been fixed up by the apex court. The 7th guideline last guideline was, if the case has been initiated with an ulterior motive for wreaking vengeance or to spite the personal grudge, then Bailer court can interfere.
That is seventh.
Seventh guideline.
Seventh guideline. Right now, the petitioner is assailing the order dated 24/7/2023 passed by learned JMFC for Kotak. Whereby the learned court below has taken cognizance of offences under section 420, 506, 294, 34 IPC against the petitioners. Also, the next one, the Learned Senior Counsel, Mr. Dhar, Learned Senior Counsel, pointed out from the record that on 8/10/2022, he has lost an FIR. Being FIR number PSC so and so. FIR number 328
of
2022, Chauliaganj, PS Chauliaganj. There are many allegations, including the allegation that the petitioner has entered into an agreement dated.
But an agreement dated
18/4/2022. 27 लिखा है 22.
22.
By which she has purchased a Tata truck number RJ19GE1357 from the accused person for a consideration amount of 23 lakhs, out of which the accused has paid, out of which the opposite party number 2 has only paid 9 lakh rupees, 9 rupees, and handed over checks for remaining amount, which got dishonored subsequently, for which proceeding under 138 NI Act has also been initiated by the petitioner. KYC complaint file kala, ye complaint na hum. The self-same agreement. On the self-same agreement, the petition, the opposite party number 2 has now filed a complaint making the petitioners accused. The result of the complaint indicates that the factual narration of the complaint is verbatim same with the FIR I mentioned above. FIR registered by the petitioner against the opposite party number 2 as mentioned. Full stop. On the basis of the said complaint, the trial court has now taken cognizance. On the same on the said complaint, trial court has now taken cognizance. Full stop. The petitioner is agreed by the said cognizance or order dated and order dated 24/7/2023. Next paragraph. Issue notice to the opposite party number 2 Opposite party number one waives notice by so. So. In the meantime, next one, in the meantime, the proceeding before the court below in the complaint case number.
Well, that is.
What is this case number? I1 CC case number P 47 of 2020.
3946 of 22. JMC now.
Conduita kona. Aude kuda jai stay you. It ଲେଖା ହେଇଛି
147 of
ଦେଖିବେ 10 ରେ ଦେଖିବେ page 10 ରେ ଦେଖିବେ
well, 140.
summons to the accused person 1 CC P 47 of 2022.
147 of 23.
23.
The pending
147 ki P1.
147.
147.
JMFC
1 CC case
correct.
number 147 of 2023 pending in the court of JMFC 4 Cuttack. State till further orders. Yes.
22.
May I please, Your Lordship?
Yes.
Sub item CR election number 4244.
Yes.
Sub item number 4244 of 2023. I am the informant in this case, my lord. I filed this application to target the trial, my lord. My limited grievance is to target the trial, my lord, out of.
Why target trial? It is FIR is 2022. You are special
yes.
accused.
Not special accused, my lord. What happened, my lord? Your lordship kindly. Last
Whatever,
page,
whatever the first petition, first.
In the first petition, senior advocate Sorry Chandra Mahapatra is appearing, Your Lordship. Due to his personal difficulty, I am seeking an adjournment, Your Lordship.
Adjourn it. Both matter.
My matter may be taken up, my lord.
Adjourn it is the only.
That may be details, my lord. What happened, my lord? I am the informant here in this case. He was no way connected. And
He is
has
accused. You are informant, he is accused.
No.
We are brothers.
No, I am for the informant, my lord.
Who are you?
I am the victim, Your Lordship. We are brothers, Your Lordship.
You are no way connected.
No. Let us understand what exactly you are trying to say. Jagdish Kumar Muni.
Yes, Your Lordship. He is the son of Lambodar Muni, who is the deceased person, Your Lordship, in this case. Against,
Arising out of the same FIR.
Yes, Your Lordship.
Then?
No. He is the son of the deceased, my lord.
Whatever.
I am for the informant, my lord.
Whatever arising out of the same FIR.
Yes, Your Lordship.
Then it can't be segregated like this.
No, what happened, my lord? I am for the informant. I am pray before your lordship to target the trial, my
That's
lord.
right. Without hearing the accused also, you being the informant, you whatever you ask.
No, I am for the informant, my lord.
I understand.
He is the son of the deceased. Since he is the son of the deceased, my lord, he is lingering the case, my lord.
Why?
I don't know, my lord.
How are you related to the informant? Deceased?
I lodged affair.
What?
I am
Who are
the
you?
proprietor. I
Who
am
are
the
you?
proprietor of the company, my lord.
Your Lordship, what happened
After death, my lord, of the Lambodar Muni, my lord, I have lodged this affair since I am the proprietor of the company, my lord.
It's all right. You were proprietor of the company.
Yes, my lord.
The deceased was working under you.
Now, I am working under the Lambodar Muni, my
He
lord.
was working under the deceased, Your Lordship, on the
Since
date
he
of
was
the...
murdered, my lord, I have lost this affair, my lord. He is the younger son, my lord, creating disturbances to linger the case, my lord.
What benefit he is going to get?
I don't know, my lord.
There must be something inside. To know only, both the petitions has to be heard together. Only to know.
Your lordship, keep it to tomorrow day after. Yes, my lord. Your lordship, keep it to tomorrow day after tomorrow, my lord.
But he has some problem.
Your Lordship, Mr. Mahapatra is due to his personal difficulties unable.
When do you want?
Lordship,
Next week?
Next week, Your Lordship.
A date may be fixed.
See, this FIR is up to 2022.
Yes, my lord. Out of 46 charge sheeted, 10 has already been examined, my lord. In the interest of the son, my lord, now the case is lingering. Otherwise,
10
the case will
witnesses,
be
10
disposed.
witnesses examined already.
Yes, my lord. Yes, my lord. Your lordship, kindly see.
present. My question is, one has lost his brother or son? One is informant. Both are-
Informant is very keen.
Yes,
and he is challenging.
He want to take
Target the
revenge
trial,
against
but
the
out
accused
of
person.
46 charge sheeted
What
witness,
is
10 has already been examined, my lord. Yeah, but due to interfere of the, my lord, son, my lord, the case is lingering.
Where do you say that 10 have already examined?
I have mentioned in para,
ठीक है, ठीक है.
yes, yes. Page 3, para 4, my lord, your lordship kindly see. Specifically, I have, about your lordship, direct the state council to take instruction.
Out
to
of
that.
69 witness, 10 examined.
Yes, my lord.
Let him take the, we'll
Yes,
take
sir.
it up next week.
Yes, date may be fixed, my lord.
Date will be fixed. 17. ठीक है?
18th, your lordship, if possible, 18th. Your lordship, on the last occasion, an interim order was passed, your lordship, in this case, your lordship, the first case.
First case. What
Yes,
is
your
the
lordship.
interim order?
Order dated 8/12/23, your lordship, may kindly see.
Yes.
Learned Government Council appearing in the case may file a petition for adjournment, which shall be considered by the
Yes.
learned court below, keeping in
Same
view.
you
This is
repeat.
the Hon'Ble, my
Your
lord.
lordship,
Same.
same, yes, your lordship, same order, because the matter is posted
Ah,
today, same order.
Yes, this is the Hon'Ble, my lord.
Why should you
Case
ask
is-
for it?
yes,
You
ma'am.
tell me, why should you ask for adjournment?
Your lordship, Mr. Mahapatra is,
No, forget about Mahapatra. Why you are the deceased son?
yes, your lordship.
If the trial is proceeding, who are you to ask for time? Why should you ask for
Your
time?
lordship, because we have challenged the petition, they have.
You may challenge whatever. How can you stall at your instance, the trial will be stalled?
Your lordship, it's not because of my instance, your lordship, I have approached this honorable court, your lordship, may kindly.
What do
see
you want in this petition?
I am challenging the recall order passed by your lordship of a witness, your lordship. The order of recalling is under challenge.
How,
your
my
lordship.
lord, is,
That we
how,
will let
local
it right.
style is.
Let the trial go on.
Yes,
Your
madam.
lordship, if the petition, if the.
No, I will not say anything. Whatever is
Yes,
going on. let
Your
it
lordship, then keep it to day after tomorrow, lordship, because my senior is appearing, lordship.
No, no, no.
Personal difficulty, I am
Eh,
paying.
But it's all right. That's the reason. 17.
Your lordship, but the
You
trial
can't
is
have
post-
both the things.
Your lordship, the trial is posted today. If the recalling petition is allowed, then this petition.
Nothing
will
is
become
going to
infructuous,
happen.
Your lordship.
We are not so powerless that we can't set the
Your
thing
lordship,
right.
but this petition will become even infructuous because the recalling petition, if it is.
If it was that so important, then you should have made alternate arrangement.
Your
No
lordship,
question.
for a
Next-
moment, kindly see the annexure
Next
one, your
item,
lordship.
next
Then-
item.
Your lordship-
23.
Your lordship, why?
Oblige,
the-
madam.
23.
Your lordship, without
23.
interim order, your lordship, the petition is examined today, then this will become.
If that
infructuous, your
was
lordship.
that was so, then you should have been serious about it. No, I will not allow
Your
the
lordship,
trial to be stalled at the instance of the deceased son.
your lordship,
If the informant says that, expedite it.
your lordship, we are not.
What
stalling
is this
it. For
going
a
on?
moment, your lordship, kindly see annexure one. your
And
lordship.
482 courts are being used for this thing to
lordship,
control
for-
the
for a
board of the trial court.
For a moment, your lordship, may kindly see annexure one, your lordship. The petitioner is approved.
I will recall the witness once if it necessary. Don't worry. You satisfy me, I will recall it.
Let's say first case कौन challenge करते ना the recall petition was allowed by the trial court.
हाँ,
That was challenged by the.
ठीक है. We will take off the take from the record his statement if you satisfy me. Don't worry.
Your lordship, but kindly protect me, your lordship, because your lordship may pass interim order, your lordship.
How are you prejudiced? I don't understand.
Because if the accused is recalled, your lordship, he may turn hostile, your lordship. That is my apprehension, your lordship.
Informant is guarded for that. Don't worry. Informant
There is a
taken-
reason, my lord. On the submission of my learned friend, there is reason, my lord.
What?
Because the person who has already been examined and cross-examined, again, behind the bar, to my instruction, the matter has been compromised. Again, he was pressed
No,
to
no. There is
depose.
nothing, my lord.
1 minute.
He was,
I have to go by
he was,
state council's.
he was forced to depose before the court that the matter.
Come
has
on,
been
come on,
settled.
then let us see.
So
You should
that
have.
is why
you
this
tell me.
is a crucial matter. It's a case of 302.
Let me see.
My friend is right. on his way.
Then right, then you should have told me.
For the court below, my lord. The son is interested to recall that evidence, my lord.
Your lordship,
I
am
just
not
already
interested
he
to
has
recall.
I just want to know whether the accused has owned over you or you.
Yes, my lord. Yes, your lordship call for
Let
a
us see.
report.
It will-
Evidence
it will-
already,
For
my
me,
lord,
your lordship, report is not
evidence is
required. your
adduced
lordship.
before the court below against the accused, my lord.
I have to go by prosecution, this thing. You tell me.
I will take instruction, my lord, particularly because what is behind this? Why this is happening? Because one is the informant, one is a brother of the.
Why do they fight? Yes.
But the recall petition was allowed by the trial court.
Huh?
There is something.
Hmm.
He is satisfied that he allowed.
Right.
Now this recall petition was challenged by the
brother of deceased.
The son of the deceased.
Son of the deceased. Why? Now the person who was examined and cross-examined, he has deposed against the accused persons. Now, whenever he will call, and the recall person already allowed, once you will go to the trial court to depose again, definitely, my lord, the first deposition of the evidence.
He will wriggle out of that.
He will
Wriggle out.
defer. That is the whole question. That is why my brother is saying.
And your lordship,
That is why he is challenging that recall. Should not be recalled. That witness should not be recalled. That is his challenge.
Your lordship disposed of on that version, your lordship disposed of the application, my lord.
17th you have put, na?
Yes, my lord.
Trial is today.
trial is today, your lordship.
By now,
Right.
it might have a
No, lordship, we have instructed the PP that the matter is registered today, and we have.
you instruct the PP
Yes,
not
yes.
to proceed.
Yes.
He will do it. Instruct the PP.
With
today.
that observation, your lordship.
No
disposed of my
observation.
lord.
This is something. It is very fishy.
No, I want to convict that accused person, my lord.
I don't know.
That was deposed before the
Who-
court
who-
below, my lord.
it is, I think it is now something transfer between the
my lord.
accused and the two
Witness.
people.
କଣ ଗୋଟେ ଅଛି ତ?
Your lordship is
ଅଛି।
making false. I am not.
ପଇସା ନେଇଯାଇଥିବେ କିଏ ଗୋଟେ
ଅଛି ତା ଭିତରେ ନହେଲେ ଏମିତି କେମିତି ହବ? ଇଏ question ଆସିବ କେମିତି?
This is very fish.
And your lordship, I have
And-
even approached this court for a CBI inquiry as well. Annexure 1, I have annexed that order. I have approached this court for a CBI inquiry in this matter because something is facing this matter.
Different things.
Why are you so interested in it? So vehement about it?
No, no, now he has stalled the proceeding, my lord. On his behest, proceeding was stalled, my lord. I wanted to convict that accused person, those
All
who
is
are.
all right, but why you are so vehement about it?
No, no, I am
May-
opposing.
may-
I am submitting before your lordship, my lord.
May I pray your lordship? Your lordship may direct the trial court to proceed with the trial, accepting PW 18.
Yes, my lord.
Accepting PW 18. Because that is the
See,
vital
it
question.
needs an hearing. I will not
Yes. Yes.
further add to
Yes.
the complication.
Yes.
You please request the PP not
Yes.
to examine this.
Right. Right. Lordship.
And we will take it up on 17th and finish up.
Yes,
both of
yes.
them.
Lordship. Right now.
Okay, 23.
23 minus.
May I please your lordship? May I please your lordship?
Yes.
Lordship, on 17 November 2020.
NBW.
NPW was issued against the present petitioner.
When was the
Petitioner died in
bail granted to you?
on 17/8/2016, the petitioner has surrendered before the trial court. And kindly glance at the page number 5 and 6.
What is the offense?
Offense under section 120B, 420, 468, 471.
The CBI case?
My lord.
You have implemented state, very CBI.
My lord,
State of Orissa. Huh?
Belgium.
Belgium.
No, that's right, but CBI is the party. State is not party.
CBI. Yes, yes, CBI.
You have not made CBI as a party.
Mr. Naik is
Mr. Naik is there.
Yes, Mr. Naik is there.
I am there, but I am not. I'm there, your lordship, but nothing has been solved to me.
That's right. I'm wondering, Mr. Naik, just see.
Accident, your lordship, accidentally I am there.
Implemented the state.
Many times they do it, your lordships. They implement state knowingly, so that
State
I will not be
is
present, they can take an
CBI is the
order.
Party, then you have to implement CBI and give a copy.
My lord.
We
Many
don't know
times they,
what is transpiring.
also many times they implement Union of India, state, so that I can't come, they can take an order.
I know. This happens.
It's a regular thing.
You implement CBI and give a copy to Mr. Naik.
My lord.
When can you do it?
After lunch. my lord.
After lunch, Mr. Naik, where is your junior? Here.
My junior is there, your lordships. Office is also there, CBI office, they can give, two people are
Sir,
sitting
the
there.
Copy in his office and come on 9th will suit you? Sarthak?
9th of February.
No.
Kali, sir. Yesterday.
January.
Tomorrow.
Like, lordship, after 16th, 17th or 18th, your lordship.
Huh?
NPW.
17th, 18th.
NBW is small matter, only just verify.
My lord, sanction did.
9th or 10th, whatever you say.
9.
Next
10th.
week, anytime,
10th,
you tell.
10th, your lordship.
10th, okay, 10th. Share the copy, 10th.
My lord.
Yes. We'll meet in.
Thank you.
What's up, madam?
time.
Okay.
Being press is some other day can be taken, preferably national candidate.
Next week, just see. Then we accommodate.
17.
Accommodate?
Yes.
Okay. 70.
Right.
Okay.
50, item 50.
Yes. Come to item. Yes.
Item 2.
The petitioner, initially case was registered, my lord. Page 6, FIR was lodged 498-302, 304B by 34 of the IPC and read with 4 DP Act, my lord. But only allegation is that, my lord, after marriage they have tortured and it is alleged that they have killed his daughter. But as per postmortem report, 302 not made out. And case of lordship turn to page 12, man. I have given the postmortem report. This is a trace was collected as per drowning side water. Test drowning side water. Case of suicidal in nature, but 302 has not initially case was registered, that has not been deleted, my lord.
302 or 304?
B.
B.
Yes, ma'am.
What
Case
is-
of suicidal in nature.
What is the
Allegation
stage? What is the stage?
Stage, my lord,
Investigation.
investigation is on.
At this stage, no interference.
The lordship call for the case diary, my lord.
No. Investigation is going on. You are asking for quashing such a serious matter.
As per
How can it-
PM report, my lord.
Whatever report may be, investigation is on, sir. The petitioner has filed this petition seeking quashing of FIR, namely PS case number you take it under section so and so. The FIR came to be registered on
30/12/21 till
20
today, my lord.
30th 12/21 and 12. Maryland Council for the State submits that the investigation of the case is still on and charge sheet has not yet been filed. The petitioners are on bail.
No, my lord. He has filed anticipatory bail that has been.
Not on bail.
And the petitioners have applied for anticipatory bail, which has been rejected. At this
Which
stage,
are directed to surrender on 3/2/2022.
rejected and
Directed to surrender, madam.
they have been directed to surrender before the
Court below.
jurisdictional court.
Yes.
Jurisdictional court. At this stage, this petition is filed seeking quashing of the FIR. Next, I'm of the considered view that at the investigating stage, jurisdiction under 482 CRPC should not be invoked, particularly when the allegations are very serious and offense alleged to have been committed under section 304B along with alleged to have been committed under 302 498A 302 304B 34 IPC read with section 4 of Dowry Provision Act. Petition dismissed. Next.
Your lordship may direct, in the meantime, 2 years has already been elapsed, my lord. Your lordship may direct the IO to submit the charge sheet, my lord.
Why should I direct? They may file close the report in your favor. Once I say something unnecessary, it will be clear complication.
It was a case of
2 years
suicidal in nature, my lord.
Maybe they are
Your lordship, within
There
a
may-
period of some period
So,
may be
see,
fixed, my lord.
At this stage, don't invite these things. It will prejudice you. Merely because for asking, for the sake of asking, you are asking. If I say something, even if they want to file a closure report, since 482 court has said they will file something. Why to invite all these things? Keep it open. Yes. Next. Huh? Next.
Item 8.
Please, your lord.
Here, Your Lordship, I am challenging the order dated 11/8/2021, where cognizance is taken against the present petitioner under section 498A, 323, 294, 506, 354, 34 IPC.
Who are you? Your husband?
No, Your Lordship. Cousin, brother, and sister-in-law.
Cousin sister-in-law.
My lord. We are staying separate.
What is the allegation against you?
Allegation is there, Your Lordship.
What is the allegation against you?
That ମୋ ସ୍ୱାମୀଙ୍କର ଅନୈତିକ ସମ୍ବନ୍ଧ ତାଙ୍କ ଭାଉଜ ସୋନାଲି ରଣା ପିଟିସନ ନମ୍ବର 2 ସହିତ ରହିଅଛି। ଏହା ଆମ୍ଭେ ଦେଖି ପ୍ରତିବାଦ କରିବାରୁ ଆମକୁ ମୋ ସ୍ୱାମୀ ଏକ କୋଠରୀ
You are Sonali Rana.
Yes, Your
And your husband is accused.
Allegations is there, my lord. On the charge sheet, my lord, also that is there.
But Pranakusto Jana, Rana and Sonali Jana.
My lord. Then her charge sheet, then her husband and elder brother-in-law, this petitioner one, Pranakushna Behera and sister-in-law Ja, Sonali Rana, torture her physically and mentally, demanding bring additional dowry from her partner. There are allegations.
How can the cognizance order be passed like this?
Your Lordship, petitioner number 1 is the cousin brother.
Whatever, there is allegation. In cognizance stage, do you want us to examine everything? Look, the petition is filed seeking passing of order dated 11/8/2021. Yes.
Permitted to withdraw, I will erase at the time of framing of charge.
That is always there. That's better idea. Let counsel for the petitioner, after arguing for some time, seeks permission to withdraw the petition to raise all the contention before the court and before the trial court at the time of framing of charges. The petition is dismissed as withdrawn with the liberty as spread.
24. 24.
Why we are so slow today?
24.
50 matters.
There is no defect. Defect has not been removed, but it has already been removed.
Okay.
The copy has not been served. The only defect was copy was not served on the Learned Counsel for the state. It has already been served.
Okay.
My lord, I am here for quashing of the proceeding on the ground of compromise between the parties. And offense, my lord, 341, 324, 325, 307, 294,
307.
307, even if 307 is there, your lordship can quash it in a given circumstances.
Yeah, that's right.
My lord, in this case, the allegation is that when on the date of
where is injury report?
Injury report, my lord.
May I pray, my lord? I contacted the IO, my lord, today morning. He stated that the charge sheet has already been submitted in meantime, my lord. Can taken up
file the charge sheet. I'll just see injury
I bring the
report.
charge sheet, my
If
lord.
it's not vital part,
my lord.
And all, then we will.
My lord, I'll bring the charge, copy of the charge sheet, my lord. Can I urgent to my lord 12th on 12th?
12th.
My lord.
I'll issue the notice and.
Notice they have already appeared, my lord.
Informant as well as the injured person.
Notice is not necessary.
No,
Only
you
I
don't have any problem because you enter a settlement. The only thing what I have to see is it's a 307 case, the vital part, whether it is attacked or not, how many days he remain in the hospital, or whether there is any influence or not. Because there are few.
12th, my lord.
12th.
My lord.
12th. Let the counsel for the state file the
charge sheet.
Charge sheet.
And injury.
Charge sheet. Least on 12th.
25.
Yes.
My lord, item 25, here the petitioner challenging the criminal proceeding matter. Your lordship may kindly peruse the complaint of the complainant. The complainant is the sub-inspector of police. Page number 10, your lordship.
You are challenging what?
Criminal proceeding matter.
Quashing.
My lord.
Okay.
Lordship may kindly peruse the page number 10, my lord. Second part. At about 6:30 AM, found one white color sumo vehicle bearing registration number this came from Belgaum side in a high speed and overtook us. A motorcycle with a pillion rider was also coming along with the sumo vehicle. As if
Are you on bail?
my lord,
And
allow the
chemical analysis report, examination report filed.
my lord, what in this case happened, my lord? The prime accused, the front row accused already acquitted, your lordship. Front row accused.
You were absconding.
My lord, the police says I am absconding.
Obviously, police says now you have absconded.
In the FIR, my lord, they say
You waited till the other accused are
Acquitted.
acquitted. Now, once a acquittal order come, you jump to the court and took the bail.
my lord, what observation made by the learned court below, your lordship may kindly peruse.
See, show me.
Page number 25.
What is your role?
My lord,
Visual-
I am the rider of the motorcycle.
Hmm.
I am the rider of the motorcycle, my lord. I am not the position holder nor
The
co-passenger.
the pillion was holding the bag.
No, my lord.
Then?
I am escort party.
You
They
are
say the
escort.
police said I am escort party.
Okay.
Your lordship may kindly peruse to page number 25.
What is the allegation against Dilip Naik?
Dilip Naik is the co-passenger. Dilip Naik and another driver name is my lord Santosh. Both are riding the Tata Sumo. They have the contraband article.
And except Dilip Naik, everybody fled away.
My lord, the police
And
allegation.
Dilip Naik faced the trial and got acquitted.
My lord.
And you also faced the trial, get acquitted.
Even
You
Lordship
get
may
the,
kindly
I will
consider the
expedite,
page number
I will
20.
expedite the trial. No installment.
All is fertile proceeding, your lordship. Even if your lordship direct.
If they will agree before the trial court that same set evidence will be filed memo to that, they will not.
I'll give a direction to expedite the trial. I tell you the.
And the same set evidence maybe utilize if they have no objection to that effect.
Thousands of matters are pending. All the matters are going on like this type only, my lord. All are fertile proceedings. This is, my lord, in the observation itself, the learned court below observed that there is no conscious possession at all. And
Where is that? Where is that?
page number 25, my lord.
Page
25.
Page 25.
After a careful consideration of the
Where?
evidence.
What page 25? There is no 25.
Page number 25.
Not 2, yes. After careful consideration of the evidence available on record
And the discussion made above, I am constrained to hold that the prosecution has miserably failed to prove the conscious and exclusive possession of the contraband article by the accused beyond all reasonable doubts, and therefore he is entitled to get an order of acquittal. He acquitted, my lord. Now the trial is.
First, the allegation. Let us see the allegation. Where it discussed.
In the page number 16, my lord. Srimati Anjali Kumar, the sub-inspector of Titlagarh PS and other staffs proceeded for the patrolling duty on the said day at 6:30 AM. The above police people found one white color Tata Sumo vehicle bearing registration number blah blah coming from Belgaum side at high speed, overtook their vehicle. They also found one motorcycle bearing registration number this coming along with the Sumo vehicle as if guiding the same. It is alleged that although the police signaled both the vehicle to stop, they advanced their speed and proceeded towards Titlagarh town. Then chased the vehicle. Thereafter, they apprehend the.
Read it.
Merit.
The motorcyclist also fled away. You are a motorcyclist.
I am the motorcycle. I am not the owner of the motorcycle, my lord.
Leaving bike at the spot.
My lord.
The police found a man inside the
man inside the Sumo vehicle was trying to escape, but was apprehended.
That is that Dilip Naik.
My lord, he disclosed his name and others' name. That statement also not recorded under 67, my lord.
You are Santosh?
No, my lord. I am
Kumbhara.
Dilip Kumbhara.
Dilip Kumbhara. Right. The petitioner invoked the jurisdiction of this court under section 482 CRPC seeking quashing of the criminal prosecution launched against him under section so. The allegation, it appears police have apprehended one Mr. Dilip Naik. Dilip Naik, it is alleged by the prosecution that on information prosecution that on which is the date of offense on 26/8/2015 at about 6 p.m. The police party chased one Tata Sumo vehicle coming from Belgaum side at a high speed. They also found one motorcycle coming along with the Sumo vehicle. It is alleged that although the police signaled both the vehicles to stop, but they did not stop, and somehow they chased the vehicle and detain the vehicle. But the driver of the Sumo vehicle managed to escape, and the motorcyclist also fled away from the spot. Only one Dilip Naik was apprehended from the spot, and the contraband. What is the contraband?
51 kg, 220 gram.
Of ganja.
Ganja.
51 kg of so ganja was recovered from the possession of Dilip Kumar Naik. Petitioner is alleged to be one of the motorcyclists. Full stop. The Dilip Kumar Naik disclosed the name of the petitioner. Full stop. Next paragraph. Meanwhile, Dilip Kumar Naik faced the trial. And by the judgment dated 20th February 20th to 2018. The learned additional sessions judge the special judge Titlagad recorded an acquittal in favor of the said accused Dilip Naik. The learned trial court records that there is no credible evidence led by the prosecution to prove the conscious possession of the contraband from the accused. Therefore, the accused Dilip Naik was acquitted. Subsequently, the petitioner who was absconding was apprehended and admitted to bail. On the strength of the acquittal order recorded in favor of the co-accused, the present petitioner is seeking indulgence of this court. Full stop. Next paragraph. I am of the considered view that the petitioner is not entitled to any relief insofar as the present petition is concerned. However, to meet the ends of justice, I am of the opinion that the trial court should proceed with the trial as expeditiously as possible, preferably within 3 months. 3 months. With the aforementioned observation, the petition is disposed of.
My lord, rest two CRLMC also there. The lordship may kindly.
Same.
No, my lord, that is different. How dita Olga আছে against CRLMC? That is different PS case and different.
जब आएगा देखेंगे. चलो अभी नहीं.
My lord, Sidita.
No priority. What is this? Dilip Kumar is one. Nikhil Chandra.
No, that is a different case, my lord.
And
both the matters
how
by
this,
Honorable Chief Justice Dr. S. Muralidhar, because
now how these matters were taken with this?
by the order of Honorable Chief Justice.
Why?
That time, Honorable Chief Justice observed the fertile proceedings are going on in different districts, my lord.
How many of them? Same story here.
Different story, ma'am. Different PS case. That is one is from Malkangiri district, another is from another.
Now, where is that order where tagging this matter? I
My
don't
lord,
understand.
Your Lordship, may I produce the order number 1 in the first CRLMC list along with this on order of Honorable Chief Justice.
A similar line we can dispose it up.
No, my lord, that is a different issues and both petitioners are not advised.
Prisoners are?
Not really, not advised.
That is the that's more of the reason that we should do that.
No, my lord, I am not prepared with the brief actually.
That you say. Adjourn, both the matters adjourn.
Within this.
No items. Adjourn to next week or whatever. Whenever the board permits, give it.
26.
Yes.
Your Lordship, in the Nikhil Chandra, that is a priority matter within any week, my lord. Within this week.
You are in
Nikhil
custody.
Chandra.
Custody. You are in custody or?
Not in custody, but.
They are not apprehended.
Not apprehended. No question. You surrender, then we will decide.
My lord, there is a fact, Your Lordship. They booked under 20B2C. My lord, but the Honorable Supreme Court in Sanjeev Chandra.
You want to argue, then I'll deal with it. You adjournment, then adjournment. Decide it. You can't have both. Try your luck, then if you dismiss, then you will ask for adjournment, not like that.
My lord, Kali as well.
Oh, Kali. Next week.
Passover, how end of the board.
Next week.
Great.
Yes.
26.
Yes.
Item 26, my lord, could I file an objection, my lord, to the IA filed by the opposite party member?
What is that IA? What is that IA? Who has filed the IA?
The opposite party number 2, my lord.
Yes, Your Lordship. I am appearing for the opposite party number 2, Your Lordship. We had filed an IA for modification of the stay of operation of order, Your Lordship. So they want to object to that also, Your Lordship.
They have a right to object, whatever. Which modification order this is? This order? Order dated 17/4/2022. What is this matter is about? Forget about the interim order. We will dispose it up. Forget it. You tell me, what is the merit? You tell me. Merit, if you have a case, it's all right. Why unnecessary hearing application? What
Your
is
Lordship, may I request for a passover, Your Lordship? Since Mr. Naik is appearing in this matter, Your Lordship is on his legs. Your Lordship may not.
Take it up the court. I will not hear interim application. I will finish it up.
Yes, Your Lordship
There
may.
is no point hearing.
No,
Okay.
in that case, Your Lordship may fix.
Today
a
there
date.
are many matters, so therefore
Your Lordship may fix a date, Your Lordship, because.
date will be given. Don't worry. Date will be given.
Yes, sir.
Yes. Next.
Interim order to be continued.
27.
Please, Your Lordship. Lordship, this matter is transferred from us. We have given the NOC.
Adjourn.
CBI matter, my lord.
Adjourn to February. Yes. 28.
28.
Please, my lord.
Yes.
My lord, here, this is the, my lord, the repetition of that, this matter. It was earlier argued before Honorable Justice Mishra. And matter was also, the judgment was also resolved. Thereafter, it has been released. Again, it has been listed. My lord, here, the petitioner challenging the order passed by the Lord and JMFC in GR case number, my lord, that is 597 of 2017. Whereas the Lord and Magistrate also pleased to convict the petitioner. The order push. Yes. Page, sir, page, internal page 25 and the external is 36. Had the convict, namely Sanjay Kesari Mahapatra, on the ground, on the quantum of sentence, he pleaded clemency is being the first offender. However, I am of the rigid view, there shall be a deterrent punishment to such persons who are involved in the commission of such kind of offences. Considering the nature and gravity of the offence, the convict is sentenced as follows. For the offence punishable under section 294/34 IPC, the convict is sentenced to pay a fine of rupees 1,000. In default to pay the fine, the convict shall undergo the simple imprisonment for 10 days. For the offence punishable under section 506-34 IPC, the convict is sentenced to pay a fine of rupees 500. In default to pay the fine of the convict shall be undergo the simple imprisonment for 5 days. For the offence punishable under section 429-34 IPC, the convict is sentenced to pay.
Now, what do you want?
My prayer is to quash the order, because absolutely the prosecution has failed to establish a case. My lord.
You are challenging this conviction order?
Yes, conviction order. Yes.
In 482?
482, yes.
Why?
My lord, there is no appeal provides, because this is a separate offence under section, my lord, that is.
Revision?
Sir?
My lord. He has to pay for appeal, my lord.
No, that is
I can see
that is not available, lord. That is not available.
1 minute, he is saying something, yes.
Yes.
Murder. 506 is there, my lord, conviction 506. 15,000 fine.
No.
Just take it up and tell me. Next week.
My lord, next week.
So far, my lord, only one thing.
My lord, for that reason, my lord, for maintainability, my lord, this case is listed, my lord.
That's right. Maintainability ground is already over. My lord, the honorable judge convinced that that is maintainable. So far, the only
Where is that order to that effect?
That is there. That is in the order sheet.
Where does it say that it is maintainable?
It is maintainable. So
where is that?
That is in the order sheet, sir. Order sheet.
Show me which order.
I was argued in the matter.
You might have argued where there is no finding on that.
But matter was also reserved. Judgment was reserved, sir. Reserved for passing the order when they are only on merit. Thereafter, it has been released. All right. Well, I will argue on merit also, because that is the decision of the honorable apex court. 482 is wider power and it is maintainable.
Wider power, if there are
that is maintainable, sir.
What wider power?
That is maintainable. Where the in petty offence, where there
okay,
is no...
let him
yes, yes, I do.
What are the
29.
29.
There is some defects, my lord. If your lordship grants me a week's time.
1 week time for curing defect. 29. 30.
Wait for
30.
February 30. 31. February.
31.
Victim and informant. I'm filing for quashing of the proceeding. While your lordship directed, victim and informant will be present. They are present, my lord.
What is the offense?
The offense is, my lord, 506, my lord.
354 and all.
323, 452, 341.
Yes. Any impediment?
My lord.
Who are they? Who is the complainant? Anybody appearing is for opposite party number 2?
My lord.
You are appearing? Okay. Who is Tilottama Pradhan and Krishna Chandra Pradhan? Krishna Chandra Pradhan. Krishna Chandra Pradhan is not there. Oh, okay. So, Santosh? Vishnu? Namita Pradhan?
Informant victim.
Ayo is there, na?
Yes, yes.
Please come. Please come. Please come. You, Puspa Pradhan. Puspa Pradhan. Have you verified these people? No problem. We can quash it. You have identified them. Lego. The present petition is filed seeking quashing of criminal proceeding arising out of FIR PS case number 158 of 2023. Nachuni PS corresponding to GR case number. What is the GR case number? You have not given. Pending the court of give the GR case number. JMC court Banapur.
These are not there.
347.
ସେ ଦି ଜଣଙ୍କୁ
ଏ-
ଡାକୁନାହାନ୍ତି
ତିନି
ଆଜ୍ଞା।
ଜଣ ଅଛନ୍ତି ଆଉ ଆସିନାହାନ୍ତି
ସମସ୍ତେ ଆସିନାହାନ୍ତି, ଦି ଜଣଙ୍କୁ ଡାକନ୍ତୁ।
ଅଛନ୍ତି ବାହାରେ
IO is there.
ସେ କୁହନ୍ତି ସେ
Oh, the accused are not there.
Oh, yeah, accused are
Complaint,
there.
we are interested in the complaint. Madam, madam, please tell your name.
ଆପଣଙ୍କ ନାଁ
Srimati Usarani Das, the SI police, being the investigating officer of the case, is present in person. All full stop. Next, all the accused persons, being the petitioners in this case, and the opposite party number 2, opposite party number 2, the informant. Informant is the opposite party number 2. Puspa Pradhan is also present. The IO has identified all the petitioner as well as the opposite party number 2.
158 case रे so far PS case no 158 is concerned.
This matter your lordship take.
Yes, yes. The parties have entered into a settlement. And have कुछ एफिडेविट वगैरह कुछ फाइल हुआ है नहीं कुछ फाइल ही चीज
Annex ଟା ଦେଇଛୁ compromise
କୋଉଟା
Joint two.
except 2 fine except 2 item 30 ना
रफानामा लिखा है
हाँ
31.
31 अरे गलत लिख दिया भैया 39 either. Where is Annex 2? Annex 2 is not there. There is no Annex, there is no settlement terms, nothing.
Annex 2 page 15.
Page
15.
It's not there in my file. Let us see the original.
रफानामा लिखा है
Scanning copy is not there. The file to give the copy. Huh? What is this you have not given? Not filed, na? How is these cases are being numbered? I don't know. Where is the index? Let us index whether it is. If index there is there, how it is not there and you have got it number? It is that not there on record. Take keep it in record. By way of Annex 2, the petitioners, the parties to the proceedings have placed on record the settlement term. All the opposite party number 2, who is present in person, is reiterating the terms of settlement before court, and IO of the case has also confirmed the fact that the parties have settled their dispute. Next one. Having taken into consideration all the facts and circumstances, attending facts and circumstances of the case, the petition is allowed, and FIR number so and so stand quashed. Next.
Next person.
Next.
PS case. What is this PS case? What is the offense?
PS case number take kindly.
PS case.
PS case number
137.
137. No, 137.
138. See the IO? Accused same? Huh?
137 ଆପଣ ଅଛନ୍ତି କି?
ନାଇଁ
ନା
158 159 ର ଆଣି
137 ରେ କିଏ ଅଛି କିଏ ଆଇଡେଣ୍ଟିଫାଇ କରିବ same
PS ନା
नहीं PS may be same. I'm talking about the accused persons.
Accused person are present.
Santosh Pradhan, Malay Pradhan. Who is Malay Pradhan? And Vidyadhar Pradhan. Vidyadhar Pradhan. Who can you identify?
It is more I know. I am 158 159.
What are the offences?
Offenses smaller. 323, 354, 366, 501, 506.
More I know, sir.
देखो तो এটা কোনো illegal impediment is there affidavit দিয়ে দেন ভালো হবে it will better file joint affidavit here today also the lordship passed out
Place it.
it cannot adapted it can adapted
Bring the affidavit and along with Aadhaar card, their Aadhaar card.
Aadhaar card.
So all photocopy. So Aadhaar card photocopy दियो. चलो. ओके
सबको 10 मिनट
कर दियो तो पास कर दो ठीक है चलो नेक्स्ट
32.
158 ର ଯୋଉ ଗୁଡାକ ଆଧାର
अरे
କାର୍ଡ
केतटा मैटर आपनकर अछि
चारटा
ମୁଁ ଦିଟା ଏଫଆଇଆର ଦେଇଥିଲି ସେମାନେ ଦିଟା ଏଫଆଇଆର ଦେଇଥିଲେ ମୁଁ
ଓ କେସ୍ କାଉଣ୍ଟର କେସ୍
ମାଇ ଲର୍ଡ ଆଣ୍ଡ ଫ୍ରେଣ୍ଡ appearing another group
यू आर appearing who is
tag नहीं माय लर्ड एंड
cross affairs
केस काउंटर
same accused person
same
you are not the IO in all any 159 you are
हाँ
right.
59 আছে
59, 158,
So
158.
in the 159 case 159 also was in the same order PS case number 159 IO same order same order and opposite party number 2 changes you opposite party number 2 is Tilotama Pradhan ठीक है 159 ଆଉ ତାହିରେ ଆପଣ ନେଇ ଆସନ୍ତୁ
ସବୁ କେସରେ ଆଫିଡେଭିଟ ଦେଇଦେବେ ଖାଲି
affidavit. चलो नेक्स्ट
ଆଉ ଗୋଟେ ରହିଲା
another 146 yes yeah question
you people don't deserve quashing you so many
ଦବା କଥା ଆଗରୁ ସବୁ ରେଡି କରିବା କଥା
yeah case 228
your case
328
arising out of same incident or what
same
same incident 146 huh
Mala.
here who all are the accused
are the accused Surendra Pradhan
ଆପଣ affidavit ଆଣନ୍ତୁ in a common judgment I pass everything
Surendra Pradhan Vidyadhar Pradhan
and Sita Pradhan
Gauri Pradhan Buddha Pradhan Pushpa Pradhan
ठीक है
They are
आनंद
accused
जान जान टाइम खराब
जॉइंट एफडी करेंगे
फटाफट
यूनिट कोर्स में कर दे सब डायरेक्ट
come by 3:30 okay
32.
May I please your lordship? The party matter has been settled between the parties and affidavit has been filed by the informant to that effect, your lordship, which is at page flag A.
offense
Your lordship.
294 506 507
507.
ना अच्छी और 9B पे एक्सक्लूसिव स्टफ है
9B of Indian
exclusive कौन recovery कौन है
The dispute started, your lordship, that
what is recovery
nothing has been it, my lord. In poultry farm, the informant.
why have they involved this 9B
The allegation is that bombing and all that.
with the bomb.
With the bomb, but it is not nothing, sir. That sort of thing has happened. Your
bomb is not recovered
no, my lord.
nothing is
My lord, what has happened, your lordship? It's the dispute started. The petition, the informant formed a poultry farm. Started a poultry farm within the village. Though villagers are opposing for that poultry farm. So dispute started, and out of that only he lodged an FIR against the petitioner with all sort of allegations.
Mr. Gada, you tell me what is the legal impediment
My lord, my there file affidavit your lordship.
Affidavit has already been filed.
Your lordship.
pass kar da huh
Investigation is going on for that reason.
But my lord, they have already
Investigation
the informant has already filed an affidavit.
For the informant.
you commit the crime threaten them get an affidavit and
No, nothing, not sir. If your lordship will,
I would let the party
My lord,
I would let the party
to bring the party.
both the party will come here and file joint affidavit so that it will be
joint affidavit file
Yes, sir. Affidavit has already.
ना joint देना थी ना
Joint देना थी.
joint affidavit ले better
ତାଙ୍କର I card ଦେଖବା
Oh
ପଡୁଛି
yes.
हाँ
My lord,
another date may be given
another date will given so that he will present
next week
Fine.
joint affidavit कर दो
next week
My lord, may direct that to both the party to present so that
you bring your certificate bring on our direction why should you
my lord,
you bring
33.
Mr. Das will conduct this case the father of the
urgent
father expert करेंगे 2 weeks after
so last week February yes 34
34. My lord, item 30. My lord, item 34 may be taken up next week, my lord.
yes 34
34 I am
34
My lord, I am appearing from BC. I may be permitted to submit from
yes
BC.
tell me
My lord, this matter may kindly be taken up next week.
urgent next week ହବ ବୋଲି ଦିଅ ନହେଲେ ତା ଆଗକୁ ଦେଇଦବ
35.
35.
Check one week time to remove the defect.
1 week time to remove it. 36.
Pass over, my lord. It was my
Pass over. 37.
37.
February. 38.
38.
February.
39.
There is a case where I challenge for framing of charge shown on the ground. But although it is a specific case of the prosecution that because of the physical relationship with the present petitioner with the girl, she became pregnant and subsequently delivered a child. But when the the DNA profile was tested, it was found to be negative. And it is the specific case of the prosecution that it is only the petitioner who has kept the relationship, and by the process she has been pregnant, subsequently begetted a child. My humble submission, under such circumstance, the entire prosecution case requires a interference by suit. Because the very basis of foundation of the very allegation, basis of allegation is that relationship.
What is the age of this opposite party?
She was around 13 years, that's a POSCO has been added. But what do it mean, madam? Because of the fact that had there been single allegation that rape, yes, there is no such expert report or DNA profile.
Where is the 164 statement?
164, my lord, that is the.
Asin sit asu.
164 statement.
ମୋ ପାଖରେ ଅଛି 39 ଅଛି 164 का है ना 38 चलছে ना
This DNA test is done at the instance of whom?
Well, the prosecution.
Where the DNA test, what does it say?
Annexure 3, my lord, page 13 to 15.
Where is that relevant part?
Page 13 to 15.
Where is the relevant part?
But here the case where the court is not going to decide the paternity of the child. It's a case. She might have relationship with other.
What he's trying to say is there is no sexual
No, only because she was pregnant. She was pregnant. The child is not belongs to the petitioner. That is the DNA report. Maybe. But is there any law that DNA report justifies that 376 will not come into operation?
Therefore, 164 statement assume importance.
Exactly.
No, even my humble submission, even if 164 will somehow support the case of the prosecution to the extent that yes, it is the petitioner who has kept the relationship. And it is one thing I may bear in mind that there is no other allegation that somebody else is a gang rape, nothing like that. So single relationship by the present petitioner with the victim.
Let us see what she says in the 164. File 1, notice. Yes, next.
Short date, because I am not praying for.
Short date to 7th February. Okay. 7th February, you get
376.3 notice to go first.
Notice
to the victim.
I have issued notice, Lakshmiput. Yes, notice. Opposite party number 2.
Yes, I have made him the other party.
Yes, yes. Yes, next.
40. Only May April. Because of the fact that if a adjournment application will be given, that will be favorably considered. That's not only the.
Do it. If doesn't happen, then you move up.
Usually what has happened earlier, it was there. Whenever application has been filed with the court, and we are filing application with the concept court.
But what is the stage now?
No, charge has been framed, and because of the fact that this report has come, no other proceeding has been there. But they are keeping the dates after the date.
It's good that the evidence should be recorded. You will be acquitted. Why to stall?
No.
You may not press this petition. If by the time next date.
Unless until this point will be advocated matter.
It is not a civil trial preliminary issues, secondary issue.
No. The concerned the victim will come and support the case. Then what more will the court will convict?
But the present position of the court,
presume everything.
The charge framed in the year 2021, 22nd March 2021. In the meantime, 2 years, I think 1 year have already been elapsed.
Report has come. That's why I am not praying for a stay. I am not praying for a stay.
Trial will see on 7th. Okay, next 40.
40.
Item 37. Item 37. Display board is showing 34.
37, nobody came. We adjourn it. Anyway, 37. We put it in February. If there is no urgency, let it come on February.
Next week, in the meantime, I will remove the defect also.
Okay, next week he is to remove defects. Next week. Yeah. Yes. 40
40,
February 40. Nobody is there.
41.
41.
The notings shows that there is some defects. So
1 week
one
time to
remove the
cure the defect. February first week. Next.
42.
42.
My lord, the petition number 1.
Sir, there are some defects. Defect number 19. There is some defect. Cure the, what is that 19 defect?
My lord, I think that is the undertaking that there are some vernacular language, those annexures, my lord, and no undertaking has been given to file the. That may be ignored, my lord.
Now, what is the case?
Yes. My lord, the petition number 1 is a practicing lawyer, practicing at Hon'Ble, my lord, and for some time he was also the president of that Hon'Ble Bar Association. And petition number 2 is a businessman, my lord, and they have filed this application under section 482 for quashing of the GR case number 186/2021, pending in the court of law and GMFC Bhopal, my lord, for offences under section 354, 364A, 365, 294, 506, 34, and 19(1)A and B of the
Money laundering.
Odisha Money Lenders Act, my lord. My lord, the fact is that an FIR has been filed by the informant opposite partner 2 to the fact that, my lord, he had taken a loan of rupees 2 lakhs from the opposite, from the petition number 1. But the petition number 1 had taken a bond of rupees, showing that he had taken a sum of rupees 15,80,000. And since he could not give that money back to the petitioner, along with the petition number 2, they went to the school where the informant was serving, my lord. They threatened him and kidnapped him to his village. And on the basis of an FIR filed by the daughter of the informant, he was recovered. But, my lord, I have filed annexure number 2, my lord, annexure number 3, my lord, may kindly see. He has himself given an application for leave from the school, my lord, where he was allegedly teaching on that very day. That is 12/2/2021, my lord. The occurrence took place.
When occurrence took place?
That 12/2/2021.
Or she might have given the leave application and coming out from the school, and that time it might have happened.
No, he has stated that while he was teaching, he was kidnapped, my lord. Such kidnapping cannot be believed, my lord, in view of the fact that he has taken the leave and has left for.
Come to the allegation in charge sheet.
Yes,
that is at page 30.
Yes, ma'am.
Yes. You are Mohanlal Das.
Lal Mohan Das.
Lal Mohan Das.
And, I'm appearing for both the petitioners, my lord. That
And Manoj Kumar Nath.
Yes.
Lal Mohan Das and Manoj Kumar Nath moved an application for bail, anticipatory bail, my lord.
They have been released on bail, my lord. They are on bail. And even after the charge sheet has been filed, nothing has been proceeded in the Learned Court below. Well, that charge sheet. Mr. Two is the leave application, my lord, the informant had given to the school.
Read the allegation.
My lord.
That may be your defense, read the allegation.
In view of the nature of the defect, my lord, this sum may be ignored.
You are only banking upon the two sentences. Banshidhar Deuri from his school, if he denied to pay, return the money. Accordingly, on the same day, that is 12/2/2021 at about 8:30 a.m., while complainant was teaching in the class 9 in so-and-so school, Lal Das along with one Manoj Nath arrived there. Lal Das abused him in filthy language and gave him push as per their previous plan and program, and made the criminal conspiracy to accomplish the objective, that is torture, exploit, and assault, blackmail, etc. Manoj Kumar has made him all these things has happened in the school. And apart from that, just see the previous allegations. You have given 2 lakh rupees and 40,000 rupees. 40,000 rupees you have been collecting. You made him to sign
yes, those are the allegations, my lord. Those are the allegations.
And blank checks were obtained from him. There are not one allegation. There are series of allegations.
No, the allegation is that, my lord, though he has taken a loan of rupees 2 lakh, but he has made him to sign on a bond paper.
All these things have to be tested in the trial.
My
How
lord,
can all these things has to be tested in trial?
true, my
There is
lord.
the question of filing.
No, so far as that 364 to 365 is concerned, my lord, that cannot believe because of the fact remains that the annexation note 2 says that the informant himself had taken leave from the school.
That has to be checked. It has to be examined, checked whether what is the veracity of that.
My lord, may kindly look at the annexation note 2.
I have seen it. I have seen it. I've seen it.
It is the handwriting of that informant.
That's right.
Who has written this application to the headmaster that since he is not feeling well, he is taking leave since 10 a.m. my lord.
You have beaten him, and therefore this all these things happen at 8:30.
8:30.
That's the allegation.
Yes.
See, at 10 a.m.
Yes.
10 a.m. he says that I'm going to hospital.
So, my lord, he was there in the school till 10 a.m.
That means he was then the allegation that he was beaten up may be correct. By 10 o'clock he says that I'll go to hospital.
Then he could have said that in the application.
He could have or should have is different thing. But the application says at 10 o'clock he is required to go to the hospital. Therefore he is taking leave. 8:30 he was beaten black and blue. That is the allegation.
Black and blue, my lord, may kindly look at that medical report. No injuries.
That is the allegation. I can't help it because this has to be tested in the trial. You may be acquitted.
Totally something different, my lord. But
so that is the whole
materials on record is concerned. If it is to be scrutinized by the, it will be said that the allegation.
No, you are absolutely correct. I am not denying that fact. You are absolutely correct. But the scrutiny at what stage and at what time? Medical thing is not also placed.
That my lord may call for that charge sheet.
You are filing for causing. You have to place certain record. Charge sheet is given to you. You have to substantiate your case.
I'll produce the
the petitioner seeks time to produce the
injury report of
the victim and other allied documents to substantiate his case. Matter is adjourned to. One week. अपन कितने time दरकार?
10 days में.
10 days. 10 days में. Next item. 43.
May I kindly pardon, my lord?
Yes.
Item 40, my lord. I become late. Item 40.
40 तो urgent है. 7.
But while I am coming on the leave date.
Urgent है क्या करेगा? There are many matters.
7. That matter has been compromised already. Let notice to go because I have already.
You have compromised.
Yes, matter has been compromised between the parties.
What is the offense?
That allegation is that the
allegation forget 307.
307, and then some injury is there.
307.
Let notice to go to the informant because as per the instruction, matter has been compromised.
Compromised, but what is the
injuries are not grievous, minor injuries are there. As per the instruction, let notice to go.
You have not placed that injury report and all. Or the 40 the petitioner is passing up for the FIR registered against him under section 341, 294, 323, 324, 307, and 34.
34, right.
That means instance of opposite party number 2. So he submits that they have settled the dispute outside the court. And then notice be issued to opposite party number 2. Also, I mean, meanwhile, the petition is directed to place on record the injury report and all other allied documents so as to substantiate his case for quashing of the FIR on the ground of settlement. Yes.
Fixed, my lord.
You go.
Grateful.
Somebody else? Someone. Date, give date, which date to give 31st.
Obliged.
Next.
44. 43. May I please, lordship? My item 43, my lord.
43.
My lord.
An applicant for quashing of the FIR in connection with the near part of the years case no 20.
What is the offense?
Offense is 363 and 506 and 34 IPC. The present petitioner and the informed daughters with the law affairs. Thereafter, they elope with the present petitioner.
Boxo is also there.
No, my lord.
Certificate can be done.
Settle his my lord. Both are married. They have got a child also.
What is the age of these 28 years and 24 years?
Certificate can be.
They're married.
Married. My lord, matters is settled.
Birth certificate. Where is marriage certificate? Aadhaar.
The child, my lord.
Where is the affidavit?
My lord, fixed
Joint
date.
affidavit.
Notice to notice.
You have settled means there is no writing. Have you entered into some settlement terms of settlement in writing or just orally?
Oral, my lord. नहीं से date fix करा जाओ से आसी के
Marriage certificate कहीं?
से इसी हिंदू ये अनुसार है लाता custom अनुसार.
Right now, the petitioner is seeking quashing of FIR number so and so. GRK so and so. Page 7, na? Page 7. At the instance of the opposite party number 2
and 3, my lord.
Opposite party number 2, na? 2 and 3.
2 and 3. 2 is the victim. 3
Who is 3?
3 is the informant, victim father.
At the instance of opposite party number 3, who is the father of opposite party number 2, the FIR came to be registered against him. Also, he submits that in the meantime, investigation is on, na?
My lord.
In the meantime,
Investigation on
he had entered into.
It is case of 2015. 15, my lord.
He is married with opposition party number 2.
Investigation on
Party number 2, and leading a successful marriage life. Therefore, he seeks indulgence. She is your wife, you can't bring her. And therefore, she seeks indulgence of this court. That notice be issued to opposite parties. The petition is directed to place on record the marriage certificate, if any, issued by the competent authority.
And date, my lord. Date.
Next time, bring her.
My lord.
Parties are directed to court reader, President of the
Nihala Prasad. Nihal Prasad, PS.
Nihala Prasad. Parties are directed to appear in person. Next date. There is over here date. Six, 7 days.
My lord.
6th or 7th, any day. 6th, 7th, whatever that day, week or next week, they do, na? February. Because they'll come in, because married, na, they are staying together.
Yes,
so he can bring.
Yes.
Maybe 30 January 30, my lord.
Next.
44. May please, Lord. Your Lordship, I am filing one IA for modification of order dated 3/1/2024. I have already corrected the copy, Your Lordship. And
what happened modification?
Because of Your Lordship, the present petitioner is not an accused in this case. He is a prosecution witnesses. So, accused he is. Order dated 3/1/2024.
No, that's right. Which paragraph? Be that age it may कौन से पढ़ देखियो?
Paragraph 1.
1.
Yes, I have corrected the copy.
Just see, show me.
Paragraph 1.
No, who has moved the application at 300?
Prosecution witness.
Witnesses have moved the application.
The informant. PW3 is an informant.
Who has moved the application under 311?
The prosecution. That has been rejected.
You are the informant.
Yes.
Prosecution has not come. You are the informant.
I am the informant, Your Lordship. Your Lordship, the prosecution has filed under section 311 petition. That has been rejected. So, Your Lordship, the PW3,
the
entire
scenario changes.
No.
Yes, of course, entire scenario. The prosecution has moved the application at 311 and it was turned down. Prosecution has no grievances. Why informant is coming forward? There is CRPC bars you. You can only assist them.
Present petitioner is the wife of the informant. PW3, that is prosecution.
You have to be sure about what you are saying.
Yes, Your Lordship.
Then the entire scenario I have allowed the application because I thought that you are the accused. You moved the application.
No. I have annexed, Your Lordship.
Where I dictated in the open court.
Your Lordship.
And not in one place, all the places it has to be changed.
No,
that means the scenario changes.
Your Lordship, for a moment, Your Lordship kindly see, I have annexed the.
Now, why should I see that?
311 petition, I have annexed, Your Lordship, in my IA, Your Lordship.
This is you. Why should you move application? This is very. If being a counsel, if you are not fair, I will not believe it henceforth.
I am submitting your.
Because see the pressure of work. If you try to mislead things, then
No, I am not misleading.
you should have told when I giving dictation. One place there is a mistake, I can understand it. All the paragraph. This is the,
Only instead of.
this is 5 paragraph. In all the paragraph there are mistakes in the sense who has moved the application is nobody knows. What is this?
Instead of accused, that is only corrected.
It makes the scenario is altogether different then. CRPC, show me the CRPC 301. Read 301. Prosecution is appearing, prosecution is keeping quiet. Prosecution is not interested.
Because of your lordship, he has not examined the medical document. That is
Whatever I don't know. Whatever.
That is a vital party.
I don't know. Whatever.
That's why your lordship, the petitioner approach before your lordship.
It has to be rooted through prosecution only. Just see 301.
Yes.
CRPC. Proviso 2.
Yes, if any such case, any private person instructs a pleader to prosecute any person in any court, the public prosecutor or assistant public prosecutor in charge of the case shall conduct the prosecution, and the pleader so instructed shall act therein under the directions of the public prosecutor or assistant public prosecutor, and may, with the permission of the court, submit written arguments after the evidence is.
So what can you do? It is a recording of evidence. They moved the application for 311, which was rejected. They don't hesitate. You challenge that and give an impression as if the accused has moved. So therefore, I allowed it.
PW3, your lordship is a prosecution witness in the trial court.
Did you follow what I'm trying to say? Have you read the provision?
I understand.
What is the limited role of informant?
Because of
Limited role of an informant is if you are appearing through counsel, you have to brief the prosecutor. Prosecutor will deal. You can't independently do something the prosecutor doesn't want. It will go in a different tangent then.
your lordship only.
Prosecutor has not made any grievance regarding non-calling of the witness. Then you are no one to ask.
Yeah, I am assisting the court, your lordship.
Assist court that
Your
you
lordship,
can't challenge.
The present petitioner is the informant in this case, and the PW3 is a vital witness, is your lordship, and he has not submitted medical documents. That's why I want to, your lordship, direct to for recall.
You should file an application through the PP.
Obviously, through PP.
You cannot come
file
directly.
482 petition, he is also keeping quiet. How would I know? How would I know? I thought that it is accused, obviously. He should have supported you. Or he should have moved application to 482.
Exactly.
And which application you have moved now?
Lordship, that is the IA number 2320 by 2024.
Go. The petitioner has moved the present application seeking modification of the order dated 3/1/2024 passed by this court. Full stop. By way of the said order, this court has allowed allowed to recall PW3 PW3 for examining him by giving a single opportunity. Full stop. The petitioner has moved this application seeking correction in the order. Full stop. In the last date of hearing, the impression was given to this court that the application under section 311 CRPC was moved by the accused, for cross-examining the PW3. Cross-examining the PW3. However, the petitioner submits that indeed the 311 application was moved by the prosecution, which was turned down. Therefore, the informant has approached this court for seeking recall of the said witness. Then counsel for the then also appearing for the state seeks instruction as to the instruction regarding this matter, as to whether they insist upon recalling the said witness or not. Let the state file response to the petition. In the light of the aforementioned submission made in the application, the order dated 3/11/2024 is recalled. Let the opposite party number 1 file response to this to the petition. They should support you, so then otherwise 301 bars you. Let them file. Yes. 45.
The question in this case, madam, there is a vigilance search in case of the petitioner manner under 13(1) and 13(1)D manner, and in that connection, his bank account has already been freezed. When the bank has already freezed, then he has filed a representation before the authority as well. My salary bank account has been freezed, and I am not able to pay my income tax dues for the current assessment years. But they have said that they have not defreezing my bank account. In this connection, I also bring your kind attention to annexure 2 manner. I have sought an application on the RTI Act. Page 80, where they have stated that the undersigned intimates that as per section 102, 160 CRPC, the bank account of both Ramachandra Jain and his wife Gituna have been freezed. Then I have filed a representation on Annex 3 manner. Thereafter, Supreme Court decision in this connection at page 25. Or it has been clearly stated.
Ratan Babulal.
They cannot defreeze my bank account by invoking section 102. Yes, 25. First, or B, that is maybe on that account it is not possible to sustain the freezing of a bank account of the appellant taking recourse to section 102 of CRPC. As the Preventive Corruption Act is a code by itself.
Yes.
He has to take recourse of 18A of the PC Amendment Act. But he has to apply before the court below. The releasing of the account under section 457. Straightway, he cannot come.
He has applied now. Where is the order?
No, he has not applied before the court.
Why have you not gone to trial court then?
I have applied to the vigilance authority who was
No,
freezing my bank account.
after seizure.
No. You have to go to the court where what is the stage of trial?
Nothing, no, till date, no charge sheet has been filed. It is
It's
still
a DA case.
as such.
Charge sheet has not yet
Not-
been
not-
filed.
But say-
Nothing is moved in that criminal court, man.
So he has to file because after search, it is to be,
So
it is
Supreme
intimated to
Court
the
decision is there,
plan
my
trial court. So he has to file an application under section 457, highlighting this legal point. The court below can address, you deal at straightway, they cannot come under section 482.
Apex court decision is there. law of the land
Maybe
is there.
apex court
Why
decision.
don't-
That's rare, but you have to go to the court at first instance. That's what he says. You file response letter. Issue notice. Returnable within 2 weeks. File response.
Lordship adjourn it.
Huh?
Adjourn it to
You tell me which day.
second week of February.
7th, 8th, whatever.
March.
February.
7th February.
Yes.
Item number 46.
Yes.
21st November, yes.
Specific direction or
Yes.
directive to obtain up-to-date instruction, particularly in respect of preliminary inquiry pending has been undertaken by the inspector of factories and boilers. The Honorable Court is very specific on this.
Right.
If it's an accident in an industry, the boiler, some accident took place, some workmen.
Last day.
Lost their life.
Hmm.
And the blast furnace.
Hmm.
But that is why inspector of factories and boiler, they have a primary role to undertake an inquiry to find out who is the person responsible for this. But in fact, here before my lords is an accounts officer. So he cannot in any way be said that he is connected to that technical work of brawler and other things. He is a chief finance officer.
Okay.
Now this on subsequent date, if I not see 7th of December 2023. The same.
Again read have you done it?
Let me clarify what is the problem.
Yes.
Have you placed it on record?
No, I have not placed, but I have obtained.
Place it on record, give me a copy.
Yes.
No, my instruction is he is writing letters to IAC instead of inspector of factory.
No, we got.
Investigation is already.
Yes.
So nice. Then
And
Assistant Director of Factories and Boilers.
Okay.
Bala
Pursuant to the
Sujan-
direction of this court dated 21/11/2023 and reiterated on 7/12/2023 to the extent that the preliminary inquiry report, preliminary inquiry needs to be carried out by inspector of factories and boiler.
Yes.
The counsel for the state submits that the preliminary inquiry has already been conducted and the report is ready. He would be filing the report before this court during the course of the day. Copy of the same may be supplied to Land Counsel for the petitioner. And list it for hearing on.
anytime convenient to my lords.
I am there. Convenience is yours. I am there. I have to be here.
Sometimes 17, 18.
Yes, 18, 19, whatever. Whichever suits. I agree with this. Thank you. 49 withdraw. Memo you have given. You take the memo. 50. Yes.
11/2013 of legal matter, itself as protected. Three conception and three natal language. Case petitioner is that yes, on 19/7/2013, at about 10 AM, Ausildar from executive magistrate. Ausildar from executive magistrate matter inspected the clinic or from clinic and made observation. Following observation, page 4, minor as of that sex determination was not being done. The age form was not there, minor problems are there, and he made and pilot case. Pilot case during number.
Whatever. Thereafter, what happened?
And in fact, and thereafter I filed a case challenging that said order. And that was withdrawn. Certificate I am doing that was withdrawn on a ground that I raised before the court because the question of non-publishing of the copy of the letter of authorization of the district appellate authority. This cognizance order was not discussed.
The pre-match, this order has not been complied by this honorable court. The order has been passed in CRMS number 6347 of 2014, dated 4/4/2016. Elaborate order, 2 pages order.
That is not placed on record.
Yes, let him to place the order.
Please submitted that this is the fact. I will not suppress it.
But you have not filed it, then how will I know?
Thereafter, several decisions have taken. It has become a cohort matter. So many government
before the trial.
That application has been approved before this honorable court 15 times.
Then you have
And it was disposed of on merit.
actually
that order also you have not filed.
authorized. That question of cognizance was not in the order. That is why it was withdrawn. It was withdrawn on the pretext of I will obtain the that authorization. So during the period, several developments have taken place. It has become a cohort matter. 3 judgments of different force. In one case,
Covered, then you go, this thing also you raise there. That is what the court earlier told you in this matter. Why are you not going to the trial court?
it is still in the national stage. It is for acceptance of put up on 13/10/2023 for supply of copy of PI police report.
Whatever.
It has not started.
Where is that order?
Yes, my lord.
Dated 4/4/16.
Annex 3, my lord.
No, 4/4/16 जोड़ा.
That order you have not filed.
Say order टा दियो.
4/4 order that my lord.
Let the counsel for the petitioner place on record. Place on record. All the 1 minute. Place on record. The order passed on 4/4/2016 in CRLM MC 6347 of 2014. The petitioner is also granted liberty to file any other or similar order passed by the coordinate bench relating to this issue. Also file karo,
My lord, that
you can't see, you obtain some order, you don't file that order. And I'll pass the order, then you, what is this? I don't understand. This is the minimum requirement. You came to 482 court, obtain some order, and you don't place that order before court.
That is not in our knowledge.
And who will decide? You will decide or I will decide?
No,
February end.
February.
End February. Because incomplete petition, I can't waste time like this. Next, 50. 50. You should extend minimum courtesy to the court. Place everything on record. The same thing happened. I gave some order to him, and today he's moving an application, changing entire thing.
That is why
I have to believe the learned counsel who is appearing. On that basis, I pass the order. Tomorrow I find that the entire thing is different.
Total different as well.
So this is dangerous proposition. So the leniency which a court is going to show, and then I can only dispose of 10 matters if I'll read everything.
Exactly.
Try to appreciate the pressure of the court. You must appreciate. If I'll keep on seeing every pleading, everything, and I'll take out the order for you, judgment for you, only 10 matter I can do.
my lord, that order to file is also attached.
It's not that.
Okay.
You have said that in the meantime there are some development. In some cases, some orders are passed.
Yes.
You are covered.
Three different.
You place those things.
My lord, I submitted.
No, you place, file it.
से जो 4416 ର order ଟା ଦିଅ
ତା ସେ ସବୁ order ଗୁଡ଼ା file କରନ୍ତୁ. So that immediately I will check, see it and allow it. Shortcut in February 2nd week. ତା ଆଗରୁ କିଛି ହେଇପାରିବ. Second week. Next, 50. Yes.
When a higher offense is made out.
Headed. You were telling me. Show me that judgment. You were telling me. Sushila Agarwal. Show me. Give me. Lisa book you have not given. Oh, he's not well today. What do you want to say there? Just
in this case, my lord, because they talk to larger cases, that whether two questions.
You have given the reference order. You tell me the final order. The reference is answered now.
Reference is the answer.
You have given me the other day. You have given me the reference order. Reference order, everybody knows. What is the answer to the reference and which paragraph?
Paragraph 33.
33. Citation give me.
Sushila Agarwal versus State.
Citation.
2020, two Supreme Court cases.
Two.
Supreme Court cases. Bracketed CRA. Case
7-1. Okay. Para?
Para 33. 34.
34. Okay.
Maybe the curtailment of power magistrate clearly showed that Parliament intended that who is granted relief under Section 430 because the arrested at the state of province because of the said pre-arrest bail. Considering this express provision, no other interpretation can be given to the sentences. The second question, therefore, is covered by the subsection. These are passed in 430 with the pre-arrest direction to release on them in the event of the subject is power granted to the court of section and the High Court on section 439(2) of the CRC. It is clear from the provision that the bail granted under section 430 is governed by section 439(2), which gives the power to the court of section and High Court to direct the arrest of the accused at any time. This ensures that no judicial intervention the balance between the two compelling principles can again be revisited if the need arises. In other words, considering any relevant change in circumstances, the prosecution can seek the arrest of the accused. The only difference is that the power of arrest in these cases is exercised only after judicial scrutiny. This provision that the court presupposes that orders once passed on section 430 and 430 will continue till a contrary order is passed on section 439(2). The order passed on section 430
and all property are not temporary or time bound. Therefore, a person enjoying a benefit of orders under this section can be taken into consideration only a specific direction is passed under section 439(2). This disposition of arrest under section 430 is different from seeking cancellation.
It's different. Then you can avail 439.
I have one of the accused. Initially, FIR was lodged on without any, all are tribal master. So one of the accused was released on regular bail and other was given 31A.
You are not 438 case.
Yes, equal to 4. After that, the charge sheet submitted adding 307. So it is a sessions tribal case. My has no jurisdiction. He has issued summon. So once I
That the reference was something different. The reference was the life of an order under 438. That was the reference. Yeah, that you show me. And all this Sushila Agarwal only in the premises that if the 438 order is there, how to apply that order? Not your case, it is all bailable offences and small offences. But now a non-bailable offence is added. What is the remedy? Remedy is a fresh bail.
Yes, sir, I am that believing. I think that under the violation of a condition imposed upon order passed from the section 438 can lead to a direction of arrest from the section 439. However, the scope of section 439 is not limited to only cancellation of it. The council stated that the provision of law was considered by this court in public rank versus Bhartam. In this case, the court, by considering an earlier judgment in Mitta Bhai Parsavai Patel versus State of Gujarat, held that by virtue of section 437(5) and 439(2), a direction to take a person into custody could be passed despite his being released on bail by a previous order. This court held that under section 439 and 439, a person could be directed to be taken into custody without necessarily cancelling the earlier bail. The difference between the cancellation of bail and a direction to take a person into custody under section 439(2) was recognized. It was also held in this case that if a graver offense is added to the affair or to the case after the person has been granted bail, a direction under section 439(2) or 437(5) is required before such person can be arrested.
So therefore, that is what I am saying. You go and surrender and get the move the application 439, 437, whatever.
Surrender.
Then
but this observation might not necessary. Without that observation,
see, that day only I said that you said that not required. I told you surrender and
in the last occasion only said that your lordship may direct a surrender in view of Sushila. Only I am that where I am
no.
only limited there.
What was the FIR against you earlier?
9.
9. Okay. The petitioner now what is it? You are asking for what? Quashing?
But that order, madam, challenging the order dated 21/5/2020.
The petitioner is challenging the order dated 21/5/2020, whereby the learned trial court has taken cognizance of offence under section page 8, under section so and so against the petitioner. So, sir, the petitioner submits that the FIR was lodged under section 341, FIR, page 9. Page 9. However, after the investigation, a graver offence, namely offence under section 307, has been added. In view of the added offence, there is a apprehension on his part that once he surrenders before court, he may be taken into custody. Despite the fact that he is on bail insofar as the other offences are concerned. Full stop. The learned counsel for the petitioners relied upon the judgment of the Supreme Court reported in 2014 to ACC 721, Sushila Kumar Agarwal and so and so. And contains that the remedy in this sequence, remedy as contemplated by the judgment is regarding, is to move the court under either under section 439(2) or section 437(5).
Prosecution.
Huh?
Prosecution have moved to an application for cancellation.
By
এটা 438 maintainable 438 তার conclusion টা হচ্ছে 438 ফাইল
430 by the prosecution for cancellation of bail and all.
नहीं ये lordship
I understand.
438 application is maintainable. He used to
I know
file
that's what I'm going to say. That's what I'm going to say. He says that you have to move an application for cancellation of bail.
Why should
it is not required? You have to get the bail.
Yes.
The land counsel for the petitioner seeks liberty to appear before the appropriate land counsel for the petitioner seeks liberty to surrender to the jurisdiction of the court below and seeks appropriate remedy under law. Appropriate law. He may surrender before the court within 10 days from today, within 2 weeks. 2 weeks and avail remedy available to him under law. Whatever remedy is available, it is not advisory jurisdiction. You can do that. What to do? Next. Yes.
On the petitioner challenges order dated 2nd December 2023 at page 19 on annexure 4 wherein learned SDM Chopper has partly rejected my application for recalling the witnesses under section 311 of CRPC and partly allowed. I have sought for recalling 2 witnesses, PW1 and PW2, while learned SDM rejected for recalling the witness PW1, but allowing PW2. The ground of challenge is that, my lord.
You are accused.
Yes, lord. I am the accused, my lord. On the ground that on 28th November, 3 witnesses. 3 witnesses present for deposition, my lord. The conducting senior counsel was absent because on that day, the bail application was posted here before High Court of the petitioner, my lord. And junior counsel was present there. The court has pursued him, her to examine. On that day, she was ill. She was suffering from fever and low pressure, your lordship. Well, lordship, may peruse the certificate has annexed to this petition under annexure 2, your lordship. And as per persuasion of the court, the learned junior counsel had put only 3 questions to the PW1, my lord. Your lordship, I have annexed the deposition under annexure 5 at page 21. She has put only 3 questions, and being a junior counsel, she forgotten to file a time petition for
come to your medical certificate.
Yes, lord. At page 16, your lord.
Read the certificate.
This is certified that
still you believe the certificate to be correct.
Hello?
Do you believe the certificate to be correct? Read, see the dates. And last line also see. She is fit for joining
for from 2nd 12/2020.
Only she has forgot 10:30 time he should have given. Time also she forgot to give the time, the doctor. This, have you seen this kind of certificate anywhere?
Actually, the right of the accused is infringed, my lord. Your lordship may peruse page 21.
She was under my treatment from 27/11/2023 to 1/12/2023.
Yes, Lord.
December. November 23 to December, 1st December.
Yes, Lord.
She is fit for joining new duty from 2/2/2023.
2/12, your lordship.
2/12/2023. 2/2/2023. It is written 2/2/20. New job, new duty. And she appeared in the court.
On 28th,
When?
your lordship.
28. So
On compulsory.
conveniently from 27th only you fell sick. But 28th you went to the court.
As because her senior was not there, she is compelling to went to the court, my lord. And your lordship may peruse, she has not put the vital questions to the witness, my lord.
Which PW1?
My lord, PW1 is the father of the victim and informant, my lord.
And who is PW2?
PW2 is a relative of PW1. Who is hearsay witness, my lord.
So here's a witness, why do you examine? He is allowed only PW.
PW2. PW2 recalling is allowed, but rejected in respect of PW1.
PW2 you have examined.
But
already.
today the case was posted today, but that witness did not appear, my lord. And one new witness was present and examined. As per my instruction, PW5 was examined today.
You let that to PW2 be examined, let us see. If further you may not required also, PW1.
Your lordship, that will be required, my lord, because PW1 is the informant and PW2 is hearsay witness who had heard from the PW1, my lord. He has deposed that the fact which has been heard from the PW1.
Now, what is the offense? 506,
506, 507 and all are magistrate tribunal 385, 506, 507, but subsequently 385 has been converted in the charge sheet to 386, your lordship.
Where is the deposition of PW?
PW1 is page 21, your lordship.
Examination.
Annexure 5.
Cross examination. Just see PW1, PW2 is allowed. PW1 he wants to examine.
Yes.
Just see page 21 and 22.
Yes.
There is virtually no questioner.
Yes, no question.
Particularly she is not well, believe or not, whatever. Huh? The counsel for the petitioner, by way of this petition, the petitioner is challenging the order dated
2nd December
2023, by which the trial court has allowed the application of the petitioner accused.
Yes, sir.
Petitioner accused.
Yes, sir.
To recall the PW2, whereas declined to recall PW1. PW1. Therefore, the petitioner is assailing this order to the extent that he wants to re-examine PW1 as well. Perusal of the he contends that the conducting council on that on that day was not well. Therefore, she could not she could not cross-examine the PW1 appropriately, and vital questions could not be put to the said witness. The Learned Trial Court taken into consideration the fact that the petitioner's counsel was not well on the day when the witnesses were cross-examined. However, allowed the PW2 to be recalled and examined, and declined to recall PW1, being the father of the minor victim, minor victim. Keeping in view all the attending circumstances, I am of the view that the petitioner accused is entitled for a single opportunity, at least a single opportunity, to cross-examine PW1 as well, apart from PW2. Therefore, the trial court is directed to recall PW1 and PW2 for on a single day, and afford an opportunity to the petitioner accused to cross-examine. Single day.
Your lordship may say on the next date.
Single day, whenever he.
On next date, so that
Today that witness was single day.
on the next date, your lordship.
On the next date appearing. On the next date. On the next date.
It is posted to 20th.
On the next date appearing. Next date appearing. Single opportunity for next date appearing. Yes.
Oblate. Origin copy.
कितने मीटर से भाई? Yes. 50.
There are 54. There are 3 defects, man.
Pure the defects.
My lord, no, that actually there is no defects. The one says that, my lord, the NLR number of my assets have not been given.
Whatever.
It is there. And the copy has not been served. In fact, the copy has been served and not been.
You got a copy?
Yes, the state council. This is the.
Yes, I have
This is a
received the
private
copy.
dispute, my lord. State has no role to but.
138 NI.
138 NI Act. 138 NI Act. In the meantime, madam, there is a compromise between the parties. I have paid the entire amount. The Annex 2 is the
counsel for the petitioner states that this case is arising out of ICC case number 40 of 2007 under section 138 NI Act and 138 NI Act. He states that in the meantime he has already settled the dispute with the complainant, that is opposite party number 1, and have settled the dispute Issue notice to opposite party number 2, returnable on Saturday.
Opposite party number 1.
Opposite party number 1, returnable within 2 weeks. Date fix कर दो. The opposite party notice to opposite party number is waived by so and so.
But there is a miscase, man. Stay proceeding. There is a IAS file. Stay of further proceeding.
Where have you filed the settlement?
Well, Annex 2, phase 20, phase 20.
And in view of the fact that the petitioner, in view of the fact that the petitioner has already settled the dispute with the opposite party number 1, and a agreement of settlement of litigation mutually dated 25/6/2022 is placed on record. The proceeding pending before the court of so and so is stayed till the next date appear. Yes.
CT case number 40 of 2017.
You might have written it.
Arrangement ICC.
Yes.
Number 56.
Yes.
Here in this case, I filed this application quashing of the entire proceeding, my lord. Since the marriage has taken place in the meantime, and page 11 marriage certificate I have annexed, my lord. Last occasion, both petitioner and the opposite party 2 and 3 appear before the
Neeraja-
honorable court.
Opposite party number 3 married to?
Opposite party number 3 married to petitioner number 1.
1.
Yes, my lord.
POXO is there.
No, POXO is not there. Charge sheet submitted, my lord, 363, 366, 120B by 34 of the IPC. This is the charge sheet copy, my lord.
Issue notice to the.
I already appeared, my lord. Last occasion, both are appeared before this honorable court. After perusing the same and directed the state council to obtain the charge sheet.
Charge sheet file kar denge.
Yes, my lord. Charge sheet is here, certified copy and 164 statement. Your lordship kindly peruse. Coach.
Yes.
I've given the certified copy of charge sheet, my lord.
Yes, Mr. Raghuda, what do you say?
164 ରେ ସେ କିଛି କହୁନି
Fine.
ପଢି ଦଉଛି ମୁଁ ବିଶ୍ୱ
Point I believe you. Marriage ହେଇଯାଇଛନ୍ତି ତ କଣ କହିବି?
ମ୍ୟାରେଜ ହେଇଛି ସାର୍ଟିଫିକେଟ ଆସିଛି
ଲେଖ।
ସେମାନେ ବି ଆଫିଡେଭିଟ ଦେଇ ଦେଇଛନ୍ତି
The
ମୋ ସିଟ୍ ହେଇଛି ବା
the petitioner is seeking quashing of the FIR PS case number so and so and the consequential proceeding thereof. Under so and so, so and so. So the petitioner submits that the petitioner number 1 has now married to the petitioner number
opposite party
number 3 in and on the basis of the said arrangement, said settlement, he seeks passing up for the FIR. The matter was taken up by the coordinate bench on 4/7/2023, and the parties were directed to present before the court. On 18/7/2023, the parties to this proceeding appeared in person. The coordinate bench of this court went on to record as follows. 18/7/30 para 3 onwards. Since the State Council was directed to seek inspection regarding the status of the investigation, the matter and submission of charge sheet, the matter is today fixed for the same. Mr. Raghuda produced to the charge sheet, copy of charge sheet, which is taken on record.
ସେ ସାର୍ଟିଫିକେଟ କପି ଦେଇଛନ୍ତି ଅନ ରେକର୍ଡ ହେଲା ପିଟିସନ ଦେଇଛନ୍ତି
I have supplied certified copy.
Charge sheet is placed on record. Charge sheet is placed on record. Mr. Raghuda submits that there is no legal impediment for quashing the FIR in view of the fact that the parties have settled their dispute, and nothing serious is alleged even in 164 statement of the opposite party number recorded. 164 statement, CRPC 164 CRPC statement recorded of the petition opposite party number 2.
3.
Opposite party number 3. Next, having taken into consideration all the attending facts and circumstances of the present case, this court is of the view that to meet ends of justice, the FIR number so and so is set aside. Therefore, all the consequential proceeding arising thereof also sand cost.
Hon'Ble.
Yeah.
Item number 57.
My lord, I'm seeking for a short adjournment.
Yes, urgent.
My lord, let it come in next week. Let it come in the next week.
Let's see which date could be given. Next week. Not next.
17 probably.
No, 30th or 31st.
Okay, no, next.
30th.
Yes.
Item number 58.
Yes, 58.
This case, your lordship, file certain documents, they lordship, before the registry. That is not came into date.
Next week.
Next week, any day.
Next week.
Entry model is there.
Huh?
Entry
Entry
model.
model. Passover item. Item number 36. Item number 36.
Yes. 36.
May I please, Your Lordship? Your Lordship knows the validity of a check with effect from 1st April 2012 is 3 months in place of 6 months. Now, these two checks, they were deposited beyond that date. Beyond three months or at best 6 months from initially from the date of issue. That is the subject matter of dispute with your lordship. Checks were deposited in July. Checks allegedly were issued on January 2012 and were deposited for the second time in July 2012.
That time it was 6 months.
That time also that expired, that 6 months had gone. 6/1, July is the 31st. So that 6 months gone. In any case, from 1/4/2021 also 3 months gone. I'm not clear.
It was subsequently again deposited.
It is at first time deposited sometimes in January. Return unpaid. He didn't initiate any proceeding. Again, he deposited in July.
Of this year, last year.
No, that particular year, 2012. I mean 2012.
Okay, July, okay.
And he got bounced in July 2000, on 18 July 2012. So that validity of the check had gone.
He prosecuted you
138 NI Act.
On this subsequent deposit or first deposit?
Subsequent.
Show me the notice.
Notice to me annex for me.
Notice the basis of 138 case.
Your Lordship may turn to the complaint petition that I have filed. Page 15.
Notice was issued in time.
From the second, he says it was issued in time. He says in his complaint petition, uh, 25/7/2012.
Thereafter it is written for on 5/12/2011. An agreement was acha. Okay. Since that.
Annexure 2 is the complaint. Your Lordship would find annexure 4 at page 20. 4. This is dated 6/1/2012. At the top, my lord. Second check is also 6/1/2012. Two checks. Now, your Lordship, if it is issued on 6/1/2012 and it deposits in on 15/6/2022, that is at annexure 5. He has not initiated any proceeding as against this refusal to pay.
No, these are invoices. What is this? This is page 20. Security check.
These are the check dates. What I am showing you, let's say check dates. And check your Lordship would find at annexure 5.
That is 30th January 2012.
Though it was issued on 6/1/2012. It was actually given on 6/1/2012. Somehow he has filled up on 30th of January 2012.
30th January.
Oh, 30th January hele bhi it is bar. Because your lordship may look at this circular at annexure 3, page 18.
Page 18.
Reserve Bank.
Hmm.
It has been brought to such and such towards the end of the third paragraph, your lordship. Accordingly, in exercise of the power conferred by section 35A of the Banking Regulation Act 1949, RBI hereby directs that with effect from 1st April 2012, banks should not make payment of checks, pay order, banker's check bearing that date on any subsequent date if they are presented beyond the period of 3 months from the date of such.
Para 2, just read. It has been brought to the notice of the Reserve Bank of Government of India that
some persons are taking undue advantage of the said practice of the bank by making payments of checks, draft, pay order, banker's check presented within a period of 6 months
from the date of the instrument, as the instruments are being circulated in the market like cash and 6 months. Reserve Bank is satisfied that in the public interest and in the interest of the banking policy, it is necessary to reduce the period within check so and so check presented for payment from 6 months to 3 months from the date of such instrument, and accordingly the index size of power 35A banking Reserve Bank will hereby and for April 1st April 2012.
2012.
What is the date of check?
It expires on 30th of June 2012. Now your lordship may kindly
check date.
Check date. CL lecture fill up it should be 6/1, but that is something again different, my lord. 30/1/2012.
30/1/2012 April ru aschi cheta 12 notification applicable from April.
So he should have
January issue kar dichi, 6 month valid.
My lord,
This instrument is 6 month valid.
This instrument will be valid for 3 months from 1/4/2012.
No. By the time this check was already issued,
that is
checks which were to be issued after April will be valid for 3 months. This is valid for 6 months.
Issued prior to that also. Prior to that, but
read the
yes, your lordship. With effect from 1st April, bank should not,
with effect from
1st April, bank should not
already the checks which were issued prior to that day will have a validity of 6 months.
Yeah, operation decision as learning. This date, check date prior to that, and whether it will take a 1st April 2012 date, that has to be considered while the lordship is considering.
I am considering that's what what is my reading is 35A notification was issued saying that with effect from a particular date, it will be 3 months. Means all instrument issued prior to that will operate by the earlier notification.
My
that
lord,
is 6 months.
I am not standing on that. The judgment I am relying on, I thought that I may not require it today. There it says, your lordship, irrespective of the date of the check, if it is in time otherwise also, but if it is deposited afterward for 2012, it has to be deposited within 3 months.
Show me that date.
So in ordinary parlance, the date would have expired on 30th of June 2012. 1/4, 1/5, 1/6.
That will not have been true.
Because had he had deposited prior to April minus, there is no quar. After April, he is depositing, so it has to be within 3 months.
I am of a different view. Because this check in subject is valid beyond 1.
I'll come with the order, with that judgment.
And have you taken this point in your reply to the statutory notice?
I have to check up that as well.
You have to see if you have not replied to the statutory notice stating all these things, then presumption under section 139 operates against you, you have to face the trial.
That is, I have come at the threshold. So after receipt of notice, I have come to your lordship. Because offense of this nature, it can be entertained and quashed. Now, if your lordship says that if I have replied that becomes again a subject of trial. So prima facie, I am trying to satisfy my lord that this complaint is not completed.
That you saw, but even then, in the statutory notice reply, you have to.
Yes,
you should
that
have,
is a.
you
that
should have
is a
told
must.
that.
But then rebuttal, that is something is required. If I have taken it, prima facie view can be taken. If I have given a reply to that, prima facie view can be taken in my favor. That is what your lordship is indicating.
No, no, if you would have replied in to the statutory notice, then onus would have been shifted to him. Since you have not replied, suppose you have not replied, then the onus is in your head.
My lord, when
That is the requirement of statutory notice.
That will come at the stage of.
So then 139 presumption will operate against you. You have to
will-
face the trial.
That will come at the stage of trial. Even if I give a reply, so moto your lordship may not accept that. Even if I say that.
No, if you have taken that stand in the reply, and despite that reply, if this kind of complaint is filed, then onus shift on his head. 139 of presumption will not operate against you.
Yes.
Then at that stage, 482 can be exercised.
Yes, that is right.
Otherwise, 482 can't be exercised. So therefore, I need to know what is the statutory notice and what is your reply.
Those two.
Then only 482.
Those two things I have to see, my lord.
How much time?
Next month. Next month.
February. Agenda. It's February 1st.
Sabu, 38 କଣ